May I please, Your Lordship? My Lord, I beg to mention item number 13. I have taken consent from the other side, my Lord. Let the matter be fixed after 3 weeks, my Lord.
You're for the
I'm for the appellant.
Rajesh R. Sonar.
Yes, I'm on behalf of our Sonar, my Lord.
You're Taku.
No, my name is not dear, my Lord. I'm Bin Yarus.
Brother.
Okay.
Return it.
Yes.
On a prayer made on behalf of Mr. R. Sonar, learned counsel for the appellant and objected to by the other side. Release the matter again after 3 weeks.
Deeply obliged, my Lord.
May I please, Lordship, I beg to mention item number 10 on behalf of K. Tama, who is appearing for respondent victim. Lordship, kindly matter may be adjourned for today since leading counsel is out of station.
Tama is out of station.
Out of station, Lordship.
See.
Who's for the other side?
I am taking the consent.
SB Darang. You are there. Any objection? When do we list it?
After 2 weeks or winter break.
ये तो कल कर लेगा या तो मंडे
Monday.
मंडे को नंबर वो मालूम इतने एकोमोडेट नहीं कर सकते now you decide what will do today
On the prayer made on behalf of Mr. K. Tama, learned counsel for the respondent victim and not opposed to by the other side.
adjustment हो गया
Matter stands adjourned for 2 weeks. Right.
Highly obliged.
Well, may I mention item number 4? Owing to my personal difficulties, my lord, I'm not fully prepared, my lord. It's because personal difficulty, my lord, on the last occasion, my lord. I went to some other place, my lord, on the way, my lord. So therefore, my lord, some accommodation may be made with the consent of the learned senior counsel and other private respondents. For
personal problem I can understand only the problem my lord the interim order is operating against it's a tender matter my lord so if my friends want accommodation let it be on Monday my lord Monday no more
again,
adjournment.
Monday, my lord, on Monday, my lord, my child will be getting holiday. So I'm going to pick up him.
That's why we have accommodation
Tuesday, my lord.
therefore you
Tuesday,
stay out accommodate
my lord, every endeavor shall be made on Tuesday to dispose of entire matter, my lord. Tuesday, my lord. By Tuesday, I'll come, my lord. Just accommodation, my lord. Otherwise,
no that part we understand but only the problem my lord interim order because working session is going on my lord
true, my lord. Then I,
Monday we have some fixed matter also.
Monday.
Thing. So Tuesday, okay. We'll
Tuesday.
decide on Tuesday.
then my lord no more adjournment my lord
My lord,
Tuesday,
true.
my lord.
Okay. And the prayer of Mr. M. Kato, learned counsel for the appellant. Matter stands adjourned to be listed again on Tuesday. Give the date.
my lord.
It is made
Ninth.
no further adjournment will be granted.
True.
My lord, my lord.
Deeply-
Interim order past
Yes.
shall continue till then.
Deeply obliged.
Yes.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 3
Three.
on behalf of the appellant counsel, G. Talo. Lordship, the counsel is out of station, Lordship, so we have taken consent from the APP as well. From the
When?
after winter break, Lordship.
What is this appeal about?
It's an appeal against the judgment passed by the learned Session Judge Bomdila, wherein the appellant has been convicted for 302 under 302 IPC.
So matter has to be admitted and paper book required to be prepared, isn't it?
Yes, Lordship.
So we can very well do that.
Yes, Lordship.
Isn't it?
I mean, the paper
Let the
book
matter
also.
be called.
Yes, sir.
As it is, it cannot be taken up for final hearing today.
Okay, sir.
So since TCR is here, we'll just examine if the paper book can be prepared. All right, you
Okay,
wait for
sir.
some time.
Okay, sir. Obliged.
Well, Lordship, I beg to mention item number 11 on behalf of the legal aid counsel, you, Body Lordship. He's out of station due to some family emergency. Matter may be fixed after 3 weeks, Lordship.
Legal aid counsel.
Yes, Lordship.
You Bori is Mr. or Miss?
Mr.
Okay, please write Mr. U Bori, Lanet Legal Aid Council. You say to be out of station on personal ground and on a prayer made on his behalf and not objected to by the other side. Matter stands adjourned for
3 weeks,
3
Lordship.
weeks.
Obliged, Lordship.
All right.
Obliged, Lordship.
May I also, I beg to mention item number 9.
Item number
9. Lordship, this matter may be kindly posted for 9 December. Due to M. Biswas is Guwahati, he is coming from Guwahati.
December.
Yes, Lordship.
Who's for the other side?
Lordship, in this case, learned AG is appearing for the state Lordship. He has difficulties on 9 Lordship, but on 5th of January, he's coming Lordship.
5th January.
5th January. Because rule is under challenge in this.
I see. So we fixed on 5th then. Let the party be there. On the request made by the Learned Council for the parties, let the matter be listed on 5th of January 2026. All right.
May I also, I'm going to mention for hearing of priority, listing on 9th December.
Which matter?
Foxo conviction.
9 December.
Yes, Lordship.
Who's for the other side? You have the appellant.
Yes, Lordship.
DB matter.
Yes,
Single
Lordship.
bench.
Conviction under POXO.
No, it's a division bench matter.
Yes, Lordship.
All right.
May it please your lordship. Lordship, I beg to mention item number 12.
12.
Your lordship, I'm not very much in a good health today, your lordship. I have some difficulties. If I may pray, your lordship may fix this matter on 16th next week, your lordship.
CP.
Yes, your lordship.
16th, you say?
Yes, your lordship.
15
is
voting.
Okay.
Voting.
Your good name?
T. Ginny, your lordship.
On the prayer of Miss T. Ginny, Lanet,
Additional people.
additional public prosecutor, and not opposed by the other side, list this matter on 16th of December.
Deeply.
Most obliged.
Item number 1.
May I please, your lordship?
Hmm.
My lord, unfortunately, prayer for adjournment.
Is it so?
Yes, my lord, because the matter is very voluminous and I was not in a, because of ill health, I was not in a position to prepare. It's regarding the, we're challenging a memorandum which was dismissed by the single judge. If I may pray, my lord, a fixed date may be given, preferably, my lord, 17th?
The appeal was admitted already?
No,
Not yet admitted?
not yet admitted. I was hoping that it
No,
could be,
it is admitted on the first day, I think,
oh, sorry, my lord.
29/9,
Yes,
2022. We'll list it for regular hearing then. No.
my lord, can it be fixed on 17th?
I don't
17th.
know. What does your friend say, Mr.
Yes, it's
Papin?
7.
Okay.
17, 18.
17th December.
Ms. N. Dungan, Learned Counsel for the appellant submits that she needs some more time to prepare the matter and prays that the matter may be posted again on 17th
17th.
of December 2025. The state prayer is not opposed to by Mr. S. Tapin, Learned Senior Government Advocate. So since the matter has already been admitted, the registry shall list this matter on 17th December 2025 in the hearing column.
Obliged.
Item number 2.
Here, your lordship, we are yet to receive the pair-wise comment, your lordship.
So,
I may be granted some more time, your lordship.
how much time?
3 weeks, your lordship.
You have received Parawai's comments, so why 3 weeks?
We have not yet received Parawai's.
Oh, you have not received?
Yes,
I
Your
thought you
Lordship.
said you have received.
No, you have received.
Okay. What do you say, madam?
I'm for the petitioner.
Okay. Good name?
Wide Ram, Your Lordship.
Mr. Y. Ram, learned
Government advocate.
government advocate, submits that he has yet to receive the Parawai's comments. And therefore, he prays that further 3 weeks' time will be granted to receive instructions to file counter affidavit. Stop. In view of above, list again after 3 weeks. Respondents to file their affidavit by the next date. All right.
Obliged.
Right.
Item number 3.
This appeal is under against what?
Again, 302 Lordship, conviction of life imprisonment.
Has it been filed within time?
Lordship,
Any delay?
Lordship, IA is there, Lordship.
The
Paperwork is ready.
Lordship, we did file IA for a condonation. It was allowed. It was allowed, Lordship.
Delay condone.
Yes, Lordship.
And what is this IA pending?
This one is for suspension of the sentence, Lordship. The
Okay.
accused appellant is currently at the Tezu jail.
Hmm.
So,
Appeal is also admitted already. Why it's listed for admission then? Hmm. Hmm. Paperbook is ready. Who has prepared this paper book?
Registry, Lordship.
Let's just see.
Yeah,
But where's the direction for preparation of paper book? Oh, it's here, okay. 26-6. Please write. The appeal was admitted for hearing by order dated 9/4/2025. And it is also seen that the paper book has already been prepared and furnished to the parties. Registry shall therefore list the matter for hearing. Before that, you write, further, the TCR is also received. Then registry shall list the matter for hearing. When?
after winter break, Lordship. After winter break.
Immediately after the reopening of the court after the winter vacation. All right.
Much obliged, Lordship.
Item number 5.
This appeal is by the state. The
I'm for the sole respondent,
Sole respondent.
private respondent.
On the last occasion, I was directed to produce the record. Here, my lord, the only issue to be determined is that such review of suspension has to be within 90 days. And the order extending the suspension, whether it should also be done within 90 days or after the review, can it be done afterwards also? Learned single judge has said that both review and the order extending the suspension has to be within 90 days. And there are judgments, earlier judgments also. Now, in this particular case, review was done within
90 days. But the order extending the suspension was 1 day later. That is the issue, my lord. It's a very narrow, the interpretation of rule 10, 6 and 7 will be required here, ma'am.
Of which rules?
CCA rules, suspension.
Central.
CCA
Central.
rules.
State
Central.
doesn't have its own.
No.
It's a central
Well,
rule.
yes, yes.
Okay.
The only issue is this, whether review, it is not in dispute that review should be done within 90 days. But the order extending the suspension, whether it can be done after 90 days, that is the only issue.
Okay.
My lord, on
So
the
what
last
happened last time?
My lord,
What was the direction last time?
to produce the records also. And there was an observation that that endeavor should be made to dispose of this matter. There is a status quo order also. On the last occasion, I had submitted 1 page of list of dates, my lord. I think it's in the file.
List of dates.
A list of dates, 1 page, only to single page. I think it is there.
Okay.
The respondent was arrested on 14/5/2024. Then his arrest was known, and then so he was suspended on 2/6/2024 with effect from the date of his arrest, my lord. Then he was released on bail on 18/1/2025. His release was intimated on 3/3/2025, and this was received on, the intimation was received on 4/3/2025. My lord, now 90 days will count as per the rules from 4/3/2025. The date of review meeting was 29/5/2025. Then the suspension order was extended on 3/6/2025 with effect from 2/6/2025. Here, if we count from 4/3/2025, the 90 days expires on 2/6/2025. Review was on time. The order extending the review was 1 day later, but with effect from 2/6/2025.
90 days will be counted from which date?
From the date when the intimation of his release from bail.
Intimation.
From the date of intimation. That is, the intimation was on serial number 5, 4/3/2025.
So 90 days will expire on
2/6/2025.
Two six.
Yes, ma'am. The review was done on 29/5/2025.
Okay. So what is the authority in this regard?
My lord,
or first of all, what about the CCS? What does it say?
CCS rules, my lord. Rule 10, 7, 6 and 7, my lord. First, I'll read sub rule 7, my lord. Rule 10.
Sub-rule?
Sub-rule 7. An order of suspension made or deemed to have been made under sub-rule 1 or 2 of this rule shall not be valid after a period of 90 days unless it is extended after review for a further period before the expiry of 90 days. Provided that no such review of suspension shall be necessary in cases of deemed suspension under sub-rule 2 if the government servant continues to be under suspension at the time of completion of 90 days of suspension, and the 90 days period in such case will count from the date of government servant detained in custody is released from detention or the date on which the fact of his release from detention is intimated to his appointing authority, whichever is later.
So that is why
Yes.
you say that on the date of receipt of intimation
Yes, my lord.
is the relevant date
Yes, my lord.
to count the
yes.
90 days.
Yes. Now, from the reading here, review, it talks about review. Review of suspension shall be made within 90 days. Now, sub-rule 6, if we read, my lord, an order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before the expiry of 90 days from the effective date of suspension, on the recommendation of the review committee constituted for the purpose. Then the word, it says, and pass orders either extending or revoking the suspension. Subsequent reviews shall be made before expiry of extended period of suspension. Extension of suspension shall not be for a period exceeding 180 days at a time. Now, here my lord will, if my lord says, the rules, sub-rule 6, there is a bracket. If we again read, an order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension. Up to here, then the bracket comes before expiry of 90 days from the effective date of suspension. My lord, this was inserted by a subsequent. It has the 90 days, if we read it, 90 days is for review. The review should be within 90 days. It emphasizes the 90 days period, before expiry of 90 days, it emphasizes on the review. The order can be passed. Once there is a review done within 90 days and a decision has been taken, if the order is passed later on also, that will not vitiate the process, my lord. Because at times, if in the fake end of 90 days, the review meeting is held, and for some or the other reason, if the order couldn't be passed on that very day, the process cannot be vitiated. Cannot be said that the authorities have not done the work. Like for this instant case also, the review was within the 90 days. It is just for one day that the order was passed.
The review happened within
90 days.
90 days. Order passed just after 90 days.
Of the order passed just after 90 days.
Then what did the learned single judge say?
Learned single judge has said that the review should also be done within 90 days. The order should also be done within 90 days.
Any reliance has been placed?
Yes, my lord. The reliance on the earlier single judgment only by this honorable court.
I see. On the same, on the same line.
Same issue,
On the same line.
same matter, same in that case also.
So how do you overcome that now?
My lord, this is a division bench. My lord. Those are judgments of the honorable learned single judge.
No, correct. It's not binding upon the division bench, but it
Yes.
may have a persuasive value also.
Yes, my lord. My lord, therefore this sub rule 6.
And when it's a ruling by a single judge and matter placed before another single judge, he can very well agree with that.
He can very well.
In case he does not agree with that,
then
may
he-
refer the matter
to a larger.
for larger bench.
Yes,
In the present case, he agreed.
he agreed.
Earlier judgment was there, I also agree.
Yes,
It should be within 90 days.
yes.
Today you say that it's not necessary.
Not necessary.
90 days, we have done the review, order may be passed a little bit later on.
Later on, no.
There's no harm in that.
No harm. This is
What reliance are you placing for that?
my lord. I'm not pressing, or I'm just on. I don't have any authority to place.
Okay, tell me about this Ajay Chaudhary you have heard.
Yes, Ajay Chaudhary
Does
talks
it say
about.
anything about that?
Not. The learned single judge. What if we see the reliance which the learned single judge was on Deepak Mali case. Deepak Mali case, 2010, 2 SCC 222, 222. Learned single judge, both the learned single judge, or the first learned single judge, he relied only on rules 10, rule 10, sub rule 7. There is no mention about sub rule 6 in the judgment in GLT Manota 485. और मेरा ये गलत किताब लेकर आ गया मतलब 2025 3 GLT 485. This is what learned single judge relied. It is by the coordinate bench. 2025 3 GLT 485. Santosh Kumar versus Union of India. My lord, the facts, my lord, will it is quite this similar, my lord. All from 10, 12.
Para 17.
17, my lord.
Come straight to para 17.
Yes.
Says order already expired after 90 days.
Yes.
It cannot be brought back to life after expiry of that date.
Yes.
That is the logic behind.
Yes. That logic was only that, and then reliance was placed at para 6, my lord. This Deepak Mali case was relied. Now, in Deepak Mali case also, it nowhere said that the suspension order has to also to be within 90 days.
Deepak Mali.
Deepak Mali, yes, 2000.
Which is the relevant para? Deepak Mali.
Deepak Mali, relevant para will be, it's a very short judgment, man. Para 10. Paragraph 10. What it says, my lord, having carefully considered the submission made on behalf of the parties and having also considered the relevant dates relating to the suspension of the respondent and when petitioners came up for review on so and so, we are inclined to agree with the views of the Central Administrative Tribunal as confirmed by the High Court that having regard to the amended provisions of sub-rule 6 and 7 of Rule 10, the review for modification or revocation of the order of suspension was required to be done before the expiry of 90 days from the date of order. What it said was only review. Para 10 also said the review for modification or revocation of the order of suspension was required to be done before the expiry of 90 days from the date of order of suspension, and as categorically provided under sub-rule 7, the order of suspension made or deemed would not be valid after a period of 90 days unless it was extended after review for a further period of 90 days. It is up to this honorable court. My lord will kindly see the records also. Everything was done in time. Only the order, I have the records, original records was asked to be placed. Now, in such cases, because if review is also done in time and the officers...
Have you flagged it?
Yes, my lord, that one.
Red flag.
Red flag.
Pink flag.
Yes.
Review was done on which date?
29/5. And order was issued.
This is also e-file.
E-file.
But it's in a thing.
That they have printed it out in this
Cartridge paper.
Yes, cartridge paper.
It looks better than
Yes.
the other one.
Yes, my lord.
You had handed over a white paper.
This looks better.
It looks like a photocopy.
File was put up to the minister and there occurred some...
Note number?
My lord, note number, I don't... there is on 30 after the...
No, what is the date of review?
29/5.
29/5.
There was a review meeting, review that will be in a separate review meeting.
Pulang Marik, is it?
Yes.
Petitioner?
Yes.
Yes.
So review happened on 29/5.
Yes.
An order was passed on?
3/6.
3/6.
3rd June. It was put up, there is a process to be approved by the Minister Home.
Order passed on 3rd June.
3rd June, with effect from 2nd June. Iya na.
This is the review, minutes of the suspension. 29 May, okay? Approved as above. Minister. Yeah.
Minister.
When was the order issued? How do we know that?
My lord, in the other pages, my lord, the order, the original
Where?
Orders. It is in our petition also. Finance are there, orders are also.
Meeting happened on which date?
29. 29/5.
29/5.
Yes.
Order on 3rd June. So the matter lies in a narrow compass.
Yes, my lord. My lord, therefore,
Whether the order passed subsequent to the expiry of 90 days would be fatal
yes,
or not. That's all.
yes. Therefore,
Your understanding about this case, what is this? Vijay
Deepak Mali.
Deepak Malik.
Yes. The Honorable
Deepak Mali is that it spoke about
review.
It does
But,
not say anything specifically about the order.
Yes, did not say anything specific about the order. It is by our own single judge that it has been held that even the order extending the suspension should be within 90 days. Deepak Mali was also confined on only up to review only. Now, therefore,
Now, in your case, review happened
within 90 days.
On review was done. Review meeting was held on 29/5/2025, and decision was taken that he should
Be
the
extended.
suspension should be extended
Extended.
for another 180 days
Yes.
with effect from 2/6/25.
Yes.
And with that decision, order was not passed immediately.
Immediately.
It was passed on 3rd June.
3rd June. With effect from?
Now, supposing if the order was passed in 3rd July or 3rd August or 3rd September or even 3rd October, then what will happen?
If it
will you say that no, review happened on this date on 29 May 25? So going back in time, we will extend the suspension period from 2nd of June. We may pass the order after 3-4 months. Where is the harm? That thing may come in. Then in such a situation, what will you do?
That may also be, but in that order has to follow. In case after 90 days there is no order, then the officer under suspension he is entitled to join. If he doesn't join, as per this rule, he is entitled to join. Now, if he comes to join, if he will automatically know whether his suspension has been reviewed and extended or not. the officer also will have a duty as per this rule to immediately go before the authority.
No, that is there, no doubt. He has to be also cautious about. He has to be uh, vigilant about his rights. That is one thing. But when there is a duty cast upon the authority, as per the CCR rules, that suspension can be done, but there has to be a timely review.
Yes.
Although you say you have the timely review, but
that occasion,
the order has become.
my lord's example that if it is passed after 2-3 months, my lord, that occasion will not arise because the officer who is seeking reinstatement, revocation of suspension, immediately he will, after the completion of suspension period, he will have to report. Then he will automatically come to know. Now, if he also is not worried to come and join back.
No, my lord, that is not correct.
No, I'm just giving an example. But because the situation is that the officer who is under suspension, immediately after the completion of suspension period, he will have to come and join. Now, if he comes and join, then he will automatically come to know.
Some people prefer to stay suspended also.
Of course. Now,
there was one case, one government servant, he submitted application for extension of his suspension because he wanted to study LLB. He had no time to go to the office. He said, please extend my suspension period so that I can study.
In fact, in our state, there was a classic example. A man was under suspension for more than 20 years.
Then what happened?
Then one fine day, he met a lawyer and then said that I'm still under suspension. He filed a case. Immediately realizing that he's still under suspension, the inquiry was conducted and he was terminated from service.
Okay.
In fact, पाँव में खुलारी मार दिया उसने.
He dug his own grave.
Yes, he dug his own grave. Well, therefore, what I submit, both the learned single judges, they have relied only on Rule 7. They have not relied on Sub-Rule 6. Sub-Rule 6, if my lord kindly again sees the bracket where it says before expiry of 90 days from the effective date of suspension, the bracket is only meant for review, reviewing authority. Or else the sentence would have been passed and pass order either extending or revoking the suspension before the expiry of 90 days. This before expiry of 90 days would have been after this sentence pass order.
One and two. What do you say about subsection 7?
Subsection 7 is clear that.
No, please read again. Subsection 7.
Any order of suspension made or deemed to have been made under Sub-Rule 1 or 2 of the rule shall not be valid after a period of 90 days unless it is extended after review for a period of before the expiry of 90 days. Extended.
For a further period.
For a further period.
Before expiry of the 90 days.
90 days.
Then
review extended after review. Here, the review was in the review it was already extended.
No, does it not connote saying that review and the extension has to be done before expiry of 90 days? You still want to segregate review? Okay.
Review
Within 90 days.
Yes.
Order maybe after
In the review, my lord, in the review, it can either, the suspension can either be revoked or extended. The review will not only mean for extending. It can either be revoked or extended. Now, here what my respectful submission will be, it says unless it is, it will not be valid unless it is extended after review. The review is done. In the review meeting, it has to be extended.
Okay, we'll consider. Anything else?
That's all, madam.
Mr. Kap.
Madam. Madam, he was my immediate senior and in Chambachinia, madam. All the way I get the knowledge from him, that madam way that he madam the place the reliance on the madam the rule 7, 6 and 7, madam. Madam, my petitioner's perspective, madam, the perspective interpretation, madam, which learned ASG, the trying to interpret that word review and the past order, madam. This cannot be segregated, madam. First of all, it has to be reviewed, order has to be passed, and Lordship may kindly appreciate one thing, that review is the process, internal process, madam. The duty and the business of the review is to recommend for further extension, madam. He will not do anything, madam. The committee, review committee has to be constituted first, madam. This is the internal, completely internal procedure, which has to be, madam, the review committee has to sit, and whether, madam, on the basing on the record, it is required to be, madam, the recommended for or not, that will be decided by the review committee, madam. And the review committee, once it is recommended, madam, recommended for extension, madam, the order has to be followed, madam. Therefore, madam, on the last occasion, madam, Article 262 has been, madam, the record, madam. So unless executive order is not communicated by order, madam, it has no valid, madam. Of course, madam, it is a division bench, madam, single bench judgment and order, which I wanted to rely, madam, is, madam, unless it is not communicated to the affected person, madam, that remains, madam, a mere, madam, the file procedures, madam, the movement, unless it is not communicated, madam. So therefore, what Learned Brain is, madam, submitting is, review is done within well time period, and the, madam, order was passed later. Lordship has madam, given a madam, beautiful, madam, example. Madam, that is, if that interpretation is comes, madam, these provisions will be, madam, no longer, madam, useful, madam. Madam, the intent of this particular rules is order as well as review as well as, madam, order has to be, madam, passed within a period of 90 days. Review cannot be segregated. Recommendation cannot be segregated for passing such order, madam. For that, madam, purpose, since we are on that, madam, particular issue, of course, it is a division bench or a single bench order, madam, which I just wanted to realize.
Yes.
Madam, of course, it is single bench order. However, madam, reliance has been made in respect of, madam, division bench, madam, and AIR 1961 is also referred, and, madam, another order of the Honorable madam, Supreme Court of 2012, SSC is also referred, madam. Madam, that has been rendered by, madam, the single bench order, madam. May I take your lordships to para 23, madam? Regarding this past and order and communication, madam, order has to be fast, order has to be communicated, for which, madam, the learned single bench has, madam, beautifully, madam, clarified, relying on the, madam, judgment of the Honorable Supreme Court, madam. Para 23, madam. May I read, madam?
Yes.
It is well settled proposition of law that an official order takes effect only when it is served on a person affected, madam. In this context, a reference may be made to the decisions of the Honorable Supreme Court in the case of Bachchiter Singh versus State of Punjab, reported in AIR 1963 SC 395, wherein it has been held that it is the essence of the order has to be communicated to the persons who would be affected by the order before the state, and that persons can be bound by that order until the order is communicated to the person affected by it. Therefore, till its communications, the order cannot be regarded as anything more than provisional in character, Malan. Exactly what I am submitting is, Malan. As relied upon by the Learned Counsel for the petitioners, the case above has been referred and considered in the case of Malan, Bifron Trading, Malan. It is reported in 2012 6 SSC, Malan. So therefore, Malan, my first limb of submission is, unless it is communicated, unless order is passed, Malan, it is a mere, Malan, the file notings, which may be taken effect, which may not be taken effect, unless order is finally passed, Malan. Now, the review has been admittedly, it seems, Malan, it has been done on 29 May 2025, but order was passed on 3rd June 2025, Malan. Therefore, Malan, both are different dates, and had it been the case that, Malan, if same is done within the stipulated period of 90 days, Malan, that will be taken into consideration, Malan. This cannot be segregated, Malan. Review as well as order has to be fast together. And this at the same Malan flow, same instances, Malan. Now, Malan, my submission is, Malan, admittedly, I was released from the custody on 18 January 2025, Malan. 18 January, Malan. My representation was submitted to the Secretary Home on 21st, Malan. They are also not disputing my date of submission, Malan.
Okay.
21 January 2025, Malan, I made representations to the authority concerned through proper channel, Malan. The proper channel, Malan, why it is required in the disciplinary force, disciplinary department, Malan, file has to be routed through grassroots level, Malan. So as to reach to the higher authorities for, they are also not disputing that part, Malan. And Malan, when I made this Malan representation before the Malan, the concerned authorities, Malan, concerned authorities who has received the order, Malan, my representation, has forwarded the same things to the Malan, the higher authorities, Secretary, Under Secretary Home, Malan, who is the competent authority, Malan. The competent authority received the Malan, the copy on Malan, or received on
4-3.
No, Malan. What is the last communication, Malan? There was several communication made between the Malan, the department as well as the Malan, the Home Department, Malan. Respondent authorities, Malan, the competent authorities and the respondent department, Malan. Since I am serving under the Malan, under the Directorate of General Police, Malan, being Malan, the Assistant Commandant, Malan. Now, Malan, my authority is the government, Malan. There was several communications made between the Malan, the authorities and the department. Malan, may kindly take note one Malan, correspondence made to the authorities concerned, which they are also not denying. Malan, page number 52 of their appeal, Malan. Annexure 4. Now, time and again, Malan, they are making the submissions that the higher authorities, competent authorities, got the information of his release from the custody is on 4th March 2024, Malan, which is factually not correct, Malan. It was not the date when the intimation was received by the competent authority. The received was done on, Malan, page number 52. It clearly speaks, Malan. 5th, Malan, correspondence date is 5th February 2025, Malan. Is the date when the competent authority got to know the release of the Malan, the petitioners from the custody, Malan. Married, Malan. Forwarding of the representation so and so, Malan, Under Secretary Home, Malan, Government of Arunachal Pradesh, competent authority, Malan. Forwarding of representation in respect of Sri so and so, Assistant Commissioner so and so. Sir, I am directed to forward here with a copy of the representation so and so, dated in respect of so and so, Assistant Commandant Simpu, seeking reinstatement in service, which is a self-explanatory. it is to inform you that Sri so and so was placed under suspensions with effect from so and so to till date by the Government of Arunachal Pradesh by order number so and so dated 2nd June 2024 for his involvement in the Itanagar PS case number so and so. I'll skip this part. And if the case is pending trial in the Honorable Court of the District and Session Judge UPR, Sri so and so has been placed under suspension for more than 8 months, my lord, by this time, my lord. It is submitted for your kind perusal and the necessary action. My lord, this has been forwarded by the Assistant Inspector General of Police, my lord, Establishment, PSQ, on 5th, my lord. My lord, kindly may see the initial, my lord, same page, my lord, just below, my lord. There is a receipt of the, my lord, this letter by the, my lord, the officer in charge, my lord, it is 12, my lord, just handwriting, 12 to 2022. Yes, my lord. Now, my lord, before filing this writ petition, my lord, I applied RTI application before the concerned authority, my lord, as well as the government, my lord. My home department, police department, as well as to the, my lord, the department of, my lord, the home, my lord. And my lord, the RTI reply, from the RTI reply, my lord, it is transpired that
regarding the date of receipt of the intimation,
my lord,
was it an issue before the learned single judge?
my lord, admittedly, my lord, at that relevant point of time, my lord, that was not raised, my lord. Admittedly, my lord.
Not raised.
Not raised.
So why do we open up at this stage? I think we are only concerned with that compass, narrow compass, saying that whether order of extension of suspension can be passed after lapse of 90 days.
No, my lord,
that much only.
My lord, I'm sorry, my lord.
Date of receipt of the information regarding your release from
that is the crucial. What is required under the rules is that the intimation with regard to the release on bail. Here, in his correspondence, he is seeking reinstatement, but there is nowhere mentioned that he has been released on bail. Neither in his representation at page 51, nor the forwarding at page 52, which my learned friend has read out. There is no mention that he was released on bail on such date.
Okay, this intimation is regarding representation for reinstatement.
Reinstatement only. But
on what
there is
ground? On what ground?
No ground. Only saying that he is under suspension.
He was released, madam.
No. Where is your representation?
At page 51.
Is at page number, madam, 51, madam.
Representation dated?
Dated 21 January 2025, madam.
No mention that he has been released on bail.
Yes, madam. I'll clarify that part, madam.
21/1/25.
Correct, madam. Madam, may I read, madam, the contents of this, madam?
No, what is this you're giving us?
Madam, this is the documents which I obtained from the RTI, which is also part of my writ petition, madam, as well as some of the documents which is the internal correspondence made between the department and the competent authority.
No, thing is that we are not inclined to entertain extra documents at this stage, because whatever was raised before the single bench.
Since record has been called, madam, that is part of the record also, madam. Just from my perspective, madam, just I wanted to clarify.
If it's a part of the record, we'll go to the record. Why should we go for an extra documents?
Madam, may I read, madam, on page number 51 again, madam. Representation, madam. With due respect, I would like to submit my grievances in connections with the aforesaid mentioned office memo that, sir, I was suspended from the post of so-and-so assistant commandant in connections to Itanagar PS case number so-and-so, so-and-so, so-and-so. The suspended effect from the date of the detention, that is 14 May 2024, in terms of the sub-rule 2 of rule the 10 of so-and-so's classification rules, madam, 1956, madam. And I shall remain under suspension, suspended until further orders. Thereafter, I am still under suspensions from my service.
All right, Mr. Kato, it's nowhere written that you're released from bail.
My lord, therefore, my lord, so as to substantiate, my lord, my plague number 3 may be, my lord, seen, my lord, kindly, my lord.
No, where have you informed the authorities that I have been released on bail? Tell us.
My lord, photocopy was given, my lord.
When?
On same date, my lord, 21 January 2025, my lord.
How?
My lord, may kindly see my plague number, my lord, just for a moment, just to clarify that aspect, my lord. Plague number 2, my lord. notes and orders, my lord. It was on representation number nil dated 21 to my lord, official note of the my lord, department. Received from so and so, so and so. The subject representation for revocation of suspension order, my lord. The representation dated so and so has been received from Sri so and so, so and so. Bail order dated 18 January, my lord, which I have enclosed in the bail order also in my writ petition, my lord. 18 January 2025, passed in bail number so and so, so and so in Itapia's case number, seeking his reinstatement in service, my lord, enclosing bail order, my lord. I separately given, of course, my lord, I admitted that part, my lord. In the my lord, representation, I have not mentioned, my lord, that enclosement, my lord. But the file noting, my lord, while that has been, my lord, clearly mentions that I enclosed the, my lord, the bail order, my lord.
But where is it mentioned in your representation?
Admittedly, my lord, that part I have not.
No, that I have
Loose, my lord, loose part on I have produced, my lord.
That
This
you have-
bail order was in my lord, writ petition, my lord. I have enclosed the copy of the bail order.
See,
my lord.
your submission was that unless it is communicated officially, things are remain redundant.
Well,
one has to be communicated. They may have done the review, but unless they communicate to me, how will I know?
my lord, I have
Similarly, in your case also,
true, my lord.
bail order is there. Unless you communicate, this is the bail order, do the necessary needful, and this is my representation. Unless you communicate, then how do you expect them to automatically
my lord, my communication,
take up things
everything,
like
my lord,
that?
as I have pointed out, my lord, this office notes clearly speaks that, my lord, bail enclosing my representation.
Oh, that we've seen. That we've seen.
My lord.
But again, the question now is that was this an issue before the learned single judge?
Correct, my lord.
That review, in fact, was very late.
Yes.
Because my bail order was already given in
That is
January.
my case in the, my lord, writ proceeding, my lord.
It was your case.
Yes, my lord.
Then what is the decision on that?
Decision is, my lord, this review, my lord, the review, my lord, decision is, if we, my lord, from my perspective, my lord, again, may I read, my lord, whichever is the communication, whichever is later, my lord. From that, my lord, that will be considered, my lord. If, my lord, may I take your lordships to again, CCS rule, my lord, to rule.
No, you tell us in the matter before the learned single judge.
My lord, it was
where was this issue raised?
My lord, my pleaded case was, my lord, I was released from the custody on, my lord, 18 January, and I intimated to the authorities concerned on 20.
Mr. Kato, please understand, this is not your appeal. This is the appeal by the state. You are not in appeal before this court saying that this date of receipt of intimation is wrong. They received in January. I've submitted my order copy of bail in January.
Yes, my lord.
That is not your case by filing a writ appeal.
Admittedly, my lord.
This is an appeal by the state. Their only objection now is that we may pass orders later on, but we have done review in time. That much only.
True, my
don't enlarge the entire thing. You see, we don't want to dig up everything and say again, go into that thing. Otherwise, we'll have to remand the matter back. That this issue was not decided. Go again and decide. But it's not your appeal.
Yes, my lord.
At the first time.
True, my lord. My lord, just to clarify that aspect, my lord, just I'm making my additional submission to that extent.
No, you don't,
Now, my
go
lord,
here and there.
yes, my lord.
You just stick to that point.
My lord,
You just tell us that why order passed after 90 days is bad. Tell us that. We'll consider that.
My lord, that part, my lord, I have already realized, made my lord, reliance on the decisions of the my lord. Of course, it is single mention, my lord.
So tell us
now,
how this authority is applicable in your case.
My lord, in my case, my lord, what I'm submitting is, my lord, it is the official, my lord, the correspondence review is the internal part unless it is communicated, my lord. So therefore, my lord, the review and my lord, the order has to be made within the effective period of 90 days, my lord. Not beyond, my lord. Even if one day is, my lord, after the expiry of 90 days, even one day delay is also, my lord, comes under this provision, my lord. That's it, my lord.
All right.
So therefore, my lord, my lord, respectful submission is, my lord, this cannot be segregated. It has to be done together within a period of 90 days. But order is passed on after expiry of 90 days, and then, my lord, the review may be done in the, my lord, month of, my lord, even within a period of 2 weeks, 3 weeks. But, my lord, the order has to be passed within the period. But the review, my lord, order cannot be segregated, my lord. So therefore, unless it is, my lord, by virtue of the, my lord, Article 2, 162, my lord, executive order, my lord, since this is my lord, on behalf of the governor of Arunachal Pradesh, my lord, state government, my lord, it has to be done. The communication has to be done within a period of 90 days, not beyond that, my lord.
Any authority you want to rely upon?
That which I have placed is the covered it is in reported in Reliance had been made in the same judgment as I have referred it is 2012 6 I've already referred order passed by His Lordship Justice Ete And on my lord,
That's it.
my lord, just another my submission is since my lord was on Deepak Mali case. In Deepak Mali case, my lord, once again, my lord, it is clearly reflected. The order and the review has to be done within a period, my lord. Just for a moment, may I take your lordships to
Paragraph?
my lord, in the my lord, appeal itself, my lord.
Appeal?
Yes, my lord.
Which appeal?
Appeal of the state, my lord.
Yes, which page?
I'm on my lord, the
Paragraph?
page number 19 is the starts from my lord, para 21.
Page 19?
Page 19, my lord, of free appeal, my lord. It is clearly, my lord, mentioned even in Deepak Mali case. And the same has been reflected in this judgment, my lord,
Page 19.
which they have. My lord, page number 19, my lord, 12, para 12. My lord, I'll not go through, my lord. I'll skip just
Page 19.
Page 19, my lord.
Para 12 means from Santosh Kumar.
My lord, from, yes, my lord, Santosh Kumar Supra.
Judgment of Santosh Kumar.
And my lord, just below 12, my lord. Para 12, my lord.
Where is Santosh Kumar otherwise?
Otherwise, my lord,
Where is the citation?
Santosh Kumar citation is
That citation 2025 3 GLT.
Oh, GLT.
Yes.
Okay, okay. Yes.
Learned single judge has relied on Deepak Mali case and quoted that.
Yes, okay. Read.
May I read para 12 again?
Read.
21 just below. It is in Santosh Kumar case, but Santosh Kumar case has relied upon the Deepak Malik case.
Correct.
A careful perusal of the rules reveal that the rule 10 mandates categorically that an order of the suspension made or deemed to have been made shall not be valid after a period of 90 days unless it is extended after review for a period beyond the expiry of 90 days. The rule, therefore, prescribes that any order of the extensions must be reviewed and also be extended before the expiry of malad. Extension is to be also done before the expiry of 90 days of the order of suspension malad issued by the authority. This rule come to the interpretations in the judgments of the apex court rendered in Deepak Mali Supra, where the apex court upheld the judgments of the High Court of the Madhya Pradesh, which had interfered with the extension of the suspension order, and which order of the High Court come to be assailed before the Apex Court. Apex Court, upon examining the entire matter as well as the CCA rules, the category held that, this is important, categorically held that the review and the modification, or revocations of the order of suspension was required to be done before the expiry of 9. Therefore,
that is why you should have gone to straight away to that case.
Yes, madam.
Deepal Mali instead of going to this judgment.
So therefore, madam, even it cannot be segregated. It cannot be taken in different counts. It has to be from the same date, from the same when the order is passed, Review has been done much earlier, the order is passed much later,
Santosh Kumar also is from a learned single judge. Therefore, before this, Santosh Kumar was relied by the another learned single judge.
I am appreciate
the Deepak Mali case. I respectfully submit that the Deepak Mali case has been wrongly interpreted in this Santosh Kumar itself. Because the Deepak Mali nowhere said that orders should also be passed. That is my case.
Spelling also is wrong. No? It should be Deepak Mali.
Yes.
It's written Deepal Mali.
That is exactly my case. Relying on Deepak Malik.
However, my lord, the
it
sum
has
is
been wrong-
substance, my lord.
wrong
The ratio is the same, my lord. The ratio is the same, my lord. Of course, naming may be, my lord, something, my lord, clerical mistake. But what the, my lord, the honorable court has rendered is the, my lord, the ratio and the, my lord, the sum and substance is the same, my lord. The law cannot be segregated by that way. My lord, I appreciate the, my lord, the interpretations which, my lord, trying to, my lord, put forward by the learned AAZ. My lord, just segregation if it is done, my lord. Otherwise, this rule will become redundant, my lord. It is of no use, my lord. So period prescribed is everything has to be done within stipulated period of 90 days.
Okay, we'll consider.
My lord.
My lord, one last submission. My lord, in fact, the learned single judge has set aside an order which was not under challenge. His main writ petition was challenging the initial suspension. When we filed our affidavit saying that his suspension has been extended, the order of extension which was annexed in our affidavit that has been set aside. Whereas there was no challenge made to that order. My lord will kindly see the prayer in the writ petition itself. Without making an independent challenge to the extension order.
That has been also observed in the learned single bench order.
My lord will come to page 40. This is the prayer portion of the writ petition.
No, tell us, is that one of your ground in the appeal?
Yes.
Where is the ground? Show us the
Yes,
ground.
first ground.
Page number?
It starts from page number 7, my lord. Page number 7, page number 8.
At page 8, ground 5. At page 8 of my writ appeal. Page number 8. Ground starts. My lord has got page 8.
See, your appeal itself is not in the proper format. There's a way of, like filing the memo appeal.
Brief
for the
attention of the
as
petitioner.
per the High Court rules.
Correct. Attention of the parties, my lord. And
Fact of
conclusion
the
of
case, contention before the learned single judge, contention of the petitioner, contention of the respondent, point for decision, point decided, then the grounds. You have adopted a shortcut method.
Of course, my lord.
Brief case, then grounds.
Even
my lord, at page 8, 5, ground 5. For the reason that the extension order dated 3/6/2025 is not under challenge in the writ petition, but the same has been said without there being
So
any.
where's the writ petition? Let us see the writ petition.
Writ petition, my lord, will find. It starts at page 25 onwards. And the prayer portion is at page 40. Page 40. 40. it is for setting aside the impugned suspension order dated 2/6/2024. This is the initial suspension order. We annex, in our affidavit, we annex this order that his suspension has been extended. In our affidavit, our affidavit starts from page 64, madam. This is the affidavit by respondent 5 and 6. Then the affidavit by respondent 1, 2, 3, and 4 is at page 55 onwards. We annexed, the respondents, we annexed this. Page 55 onwards is the affidavit of 1 to 4. So, well, my contention will be that both learned single judge in Santosh Kumar case also, they have wrongly interpreted the Deepak Mali case. There was no pleading, no challenge made to the impugned order, the order which has been set aside.
So the initial order of suspension was challenged.
Yes.
On what ground?
Malat 90 days period has been expired. There is no malat the extension malat. No review malat. So therefore, malat the purported review extension will have no validity malat.
No, that is regarding the extension. But your writ petition was
Filed much before malat. When malat my writ petition was filed on, malat my kindly take that malat my
no, kindly see the prayer portion at page 40.
admittedly malat.
You have challenged your initial suspension order dated 2/6/2024.
Yes, malat.
On what ground?
Malat 90 days has already.
No,
been-
not 90 days. 90 days came later on. You have challenged the first order itself.
Yes, madam.
On why? On what ground?
Malat ground is malat the as I have malat pointed out. Malat without reviewing the 90 days after expiry of 90 days period, malat the malat my suspension initial suspension become malat invalid malat. Malat there has to be malat the revocation of my malat
When did you file your writ petition?
on malat therefore malat 1st May 2025 malat 1st May malat in the month of May malat after the issuance of the notice by this honorable court this impugn suspension order has been passed. In Deepak Malik case also, my lord, when the my lord, even there is no my lord, the my lord, past suspension order has no validity, my lord, subsequent will become my lord, automatically invalid, my lord. My lord, notice was issued on 9 my lord, May 2025, my lord. This by this honorable court, my lord. And thereafter, my lord, the subsequent my lord, extension order was passed on during the pendency of this writ petitions, my lord. And other way, my lord, if my lord, my initial suspension order has no validity, my lord, if lordship interfere, my lord, set aside, my lord, and quash, my lord, my initial suspension order, my lord, then my lord, this my lord will automatically become my lord, redundant, my lord. Therefore, my lord, that has been my lord, that has been my lord addressed by the learned single bench, my lord. My lord, may kindly come to the page number, my lord. What honorable single bench has observed, my lord. Page number, my lord, 21 of writ appeal, my lord. It is during the currency of the, my lord, the initial suspension order, my lord. Page 21, my lord. The judgment and order passed by honorable single bench, my lord. Relying on this judgment, it is submitted on behalf of the petitioners that the respondent department reviewed the suspension order dated 3rd June 2025 after expiry of 366 days during the extent currency of the petitioner suspension, my lord. My lord, how I can make, my lord, which is not at all force that can be, my lord, when the writ, more particularly when the writ petition is pending before this honorable for court consideration, my lord.
Now, what does it mean? The respondent department reviewed the suspension order dated 3/6/2025.
My lord, during the substance, my lord,
No. Please see the language. The review has to be done on the suspension of the order dated 2/6/24, isn't it? That has to be reviewed.
Yes, my lord.
Subsequent extension is 3/6/25. So this is an order extending the previous suspension.
My lord, why
This is not a review.
My lord, may I kindly appreciate till 3rd June 2025, my lord. This is on currency, my lord. My initial suspension was on current, my lord. Is existing, my lord.
Which suspension order has been reviewed?
That initial suspension order, my lord.
So read this line, page 21, which you just read. 3/6/25 has been reviewed.
That is, my lord, after the expiry of 90 days.
See, just read paragraph 22, second line.
Paragraph 22 is, my lord.
Respondent department reviewed. Read.
Review, my lord, relying on the judgment, it is submitted on behalf of the petitioners that the respondent department reviewed the suspension order dated, my lord, order dated 3rd June 2025.
Stop there.
My lord.
So what was reviewed? Order dated 3/6/25 was reviewed. Reviewed by which order?
My lord, to my lord, respectful submission.
So that's why I'm saying the language problem is
That's why this figure is not correct, my lord. It has to be, my lord, 2nd June, my lord.
Correct. So
2nd June, my lord.
So there's a typo error.
My lord, this has been
We've
brought.
understood, Mr. Kato. We've
My
understood.
lord, that has to be, my lord, that was brought to the notice of the, my lord, the registry on the last
All
occasion, my
right,
lord.
we'll consider.
My lord, I have completed my argument.
Mr. N. Ratan. Learned additional advocate general. For the appellant. And Mr. M. Kato. Learned counsel for the
Sole respondent.
sole respondent, public writ petitioner. Stop. This is an intra-court appeal preferred against the judgment and order dated 21/11/2025 passed by the learned single judge in WPC number 195 AP/2025. By which please come to page 24 of the appeal.
Yes, Malad.
Paragraph 32, the last line. Order number so and so dated 3rd June 2024.
3rd June 2024.
What is this order?
This is the extension.
Extension order passed in 2024.
25 clerical typographical.
mistake again.
Yes.
By which, please write the order of extension of the suspension of the respondent. Right order dated 2/6/2024 was set aside.
3/6.
Suspension order is 2/6, isn't it?
Yes.
Ah. So I'm referring to that.
Oh, yes.
But this is a mistake, so no point. Next para. Mr. N. Ratan, learned additional advocate general, at the outset submits that the issue involved in the instant writ appeal lies in a narrow compass. Now he submits that the question is as to whether the an order extending the suspension period can be passed after a period of 90 days. After the suspension order has been reviewed within the 90 days period of time. He submits that when review was indeed done within 90 days period, comma, there would be no harm in passing an order subsequently after the lapse of 90 days, since there is no restriction as such. Under the provisions of CCA rules 1965. Stop. He submits that in the instant case, the learned single judge, relying upon the decision of an earlier judgment of a single judge in Santosh Kumar versus Union of India and others, reported in 2025, 3 GLT 485. Had interfered with the extension of the suspension of the petitioner, of the respondent, on the ground that the same was passed after a lapse of 90 days. Of the learned additional AG further submits that the learned single judge, while passing the learned single judge in Santosh Kumar Supra had misinterpreted the judgment of the apex court in Union of India and others versus Deepak Mali, 2010, 2 SEC 222. So referring to the said decision, the learned additional AG submits that according to the apex court, review of the suspension period has to be done within 90 days. And the apex court did not mention that such an extension has to be done by passing an order within 90 days. To stop in this regard, the learned additional AG has also drawn the attention of this court to Rule 10, bracket 6 of the CCA Rules 1965, wherein the expression within inverted comma before expiry of 90 days from effective date of suspension, close inverted comma, has been kept within a bracket and thereby meaning that review has to be done within 90 days. Stop. The same, however, does not no, cancel that. The same is not the prescription in case of an order to be passed after such a review is done. Stop. He therefore submits that the extension of the suspension of the respondent may have been done after the expiry of 90 days, but when the review itself has been done within a period of 90 days. Comma, the extension of the suspension has been rightly passed and should not have been interfered with by the learned single judge. Stop. Next para, Mr. N. Ratan, learned additional advocate general, further submits that the respondent, by filing his writ petition, had challenged the initial suspension order dated 2/6/2024. And whereas the learned single judge has interfered with the order passed subsequently, extending the suspension, which was not even a subject matter of challenge in the writ petition. Stop. Such being the case, the impugned judgment and order is not sustainable and should be set aside. In order to substantiate whether that the review of the suspension period had been done within a period of 90 days, the learned additional AG has also produced the 11 departmental records before us. Mr. Ratan, anything else?
No.
Next para, per contra, Mr. M. Kato, learned counsel for the respondent, submits that although review may have been done within the period of 90 days of suspension of the petitioner, but without a communication made to the petitioner in that regard, comma, the same is of no avail. So, in other words, comma, the learned counsel submits that since the petitioner was not informed about the extension of his suspension period by passing appropriate order within the period of 90 days. His prolonged suspension is only illegal, and the learned single judge had rightly interfered with the order of extension of the suspension period. Full stop. He submits that the petitioner, the respondent, in fact, had submitted a copy of the order by which he was granted bail. That is bail order dated 18/1/2025, along with his representation dated 21/1/2025. Before the authority concerned. But despite the same, the petitioner was not reinstated, and for which reason he had to approach this court by filing his writ petition. On 1/5/2025. Full stop. He submits that as on the date of filing of the writ petition, the suspension period of the petitioner was not reviewed, and no order to that effect had been passed and furnished to the petitioner. Full stop. It was only during the pendency of the writ petition that the respondent authority is concerned. Passed the order of suspension, the order of extension of the suspension period dated 3/6/2025. Stop. Since the same was not passed within the period of 90 days as mandated under the CCA rules, the same is not sustainable. And the learned single judge rightly interfered with the impugn action of the respondent authorities. Now he submits that the decision of the learned single judge you cancel that part again. He submits that in coming to such a conclusion, the learned single judge had rightly relied upon the decision of a coordinate bench of the court in Santosh Kumar Supra, which again relied upon the apex court decision in Deepak Mali Supra. So under the circumstance, the learned counsel submits that no interference is called with the impugned judgment and order, and the instant writ appeal should be dismissed. Stop. We have heard the submissions made by the learned counsels for the rival parties, and we have perused the materials available on record, including the record produced by the learned additional AG. Next para. For the purpose of considering and disposing of the instant writ appeal, brief facts may be noticed at the outset. Stop. The petitioner was arrested on 14/5/2024, and for which reason he came to be suspended by order dated 2/6/2024 with effect from 14/5/2024. Stop. Subsequently, the petitioner was released on bail on 18/1/2025. And a communication to that effect was received by the authorities concerned on 3/3/2025. Stop. Although according to the petitioner, he had submitted the bail order dated 18/1/2025 along with his representation dated 21/1/2025. But we do not find any mention about the petitioner having been released on bail or a copy of the bail order being enclosed in his representation dated 21/1/2025. Stop. Therefore, the date of intimation about his release on bail, as accepted by the official, accepted by the writ appellants as 3/3/2025, will have to be accepted. Not 3/3, you make it 4/3.
And on record, it is 3/3.
3/3 or 4/3?
4/3.
4/3.
Page 16, judgment. Era 9.
Annexure. Page 62 is the order, madam. Page 62. Intimation. This was received on 4/3.
Stop. The same can be seen from Annexure 1 to the writ petition. Writ appeal, which is a communication from the Assistant Inspector General of Police, (E), PHQ, Itanagar, to the Under Secretary to the Government of Arunachal Pradesh, Home Department. While the petitioner, being aggrieved with his prolonged suspension, approached this court by filing his writ petition on 5/2025 with a prayer for setting aside and quashing the suspension order dated 2/6/2024. The record reveals that his suspension was reviewed by a constituted body of members which held its meeting on 29/5/2025. The records reveal that after detailed deliberation and taking into consideration the charges against the petitioner, it was considered necessary for extending his suspension period for another 180 days with effect from 2/6/2025. Of the recommendation of the review committee consequently came to be approved by the competent authority on 3/6/2025. And accordingly, an order of extension of the suspension period for 180 days with effect from 2/6/2025 was passed on 3/6/2025, which was after the expiry of 90 days from the initial period of suspension and during the pendency of the writ petition. Of the issue, therefore, to be considered and decided is as to whether the same would be permissible in law. Stop. In other words, if the review, when the review was held within the period of 90 days from the initial date of suspension, recommending the extension of the suspension period, but the order itself being passed after a lapse of 90 days would be permissible in law. Stop. In this connection, we will have to revert back to what is provided under the CCA rules, more particularly Rule 10. Bracket 6 and bracket 7. Stop. Not stop, we continue, which is abstracted here under for ready perusal. A to A. Page 67, okay?
My lord, in this Rule 7, there is an amendment which is not incorporated in the books, my lord.
Where's the amendment?
Amendment last time also it is still not incorporated in the book. It is almost similar. Only the proviso is, there is a added proviso. total date of days of suspension period has been given.
But is it relevant to our case?
No, that's
Not relevant.
Not relevant.
Then I think we should not.
Okay.
From the next para, from the above abstract, it may be seen that an order of suspension made or deemed to have been made has to be reviewed by the competent authority before expiry of 90 days with effect from the date of suspension. On the recommendation of the review committee constituted for the purpose and pass orders either extending or revoking the suspension to stop. Further, as per sub-rule bracket 7 of Rule 10, it is provided that order of suspension made or deemed to have been made shall be valid for a period of 90 days unless it is extended after review for a further period before the expiry of the 90 days. So, what can be seen is that the suspension remains valid for a period of 90 days. And thereafter, it may be extended subject to such extension being made before the expiry of 90 days. Of the apex court is Deepak Mali. In the given facts and circumstances of that case, at paragraph number 10 of the said judgment, held as follows. Please abstract paragraph 10. A to A, page 224. Next para, from the above abstract, it may be seen that the apex court agreed with the views expressed by the Central Administrative Tribunal and which was confirmed by the High Court in respect of sub-rule bracket 6 and bracket 7 of Rule 10 of the CCA rules 1965, that the review for modification of or revocation of the order of suspension is required to be done before expiry of 90 days from the date of order of suspension. And as categorically provided under sub-rule bracket 7, the order of suspension made or deemed made would not be valid after a period of 90 days unless it was extended after review for a further period of 90 days. So by conjoint reading of sub-rule bracket 6 and bracket 7 would therefore go to show that the extension of the suspension period has to be within 90 days. Stop. The reason is that sub-rule bracket 7 of Rule 10 clearly provides that the order of suspension would remain valid only for 90 days. Stop. In other words, it shall not be valid after a period of 90 days unless extended. Stop. If the proposition of the appellants is to be accepted, that since the review itself was done within the 90 days period, passing of an order subsequent thereto would not be fatal. It may so happen that review was done within 90 days, but the extension of the suspension came to be passed much later on. And the same would still be considered to be valid. Such proposition in our considered view cannot be accepted for the simple reason that the validity of the suspension order is restricted to 90 days. Passing an extension order after the lapse of 90 days period would not mean that this would not amount to passing of an order of extension of the suspension period, but would literally amount to passing a fresh order of suspension. Of such being the position, we are of the considered view that the extension of the suspension period by an order passed after a lapse of 90 days would not be tenable in law. Next para. With regard to the submission made that the order dated 3/6/2025 extending the period of suspension not being a subject matter of challenge in the writ petition, the impugned judgment and order therefore should be set aside, we are of the view that as on the date of filing of the writ petition, that is 1/5/2025, there was neither a review of the suspension period of the petitioner and much less an order extending the suspension period. Further, the petitioner was placed under suspension via order dated 2/6/2024 with effect from 14/5/2024. While an intimation about his release on bail was received on 4/3/2025, you just read the sentence, please. Before that. Before that. Yes.
not being said, but the measure actually being local, other, which is an order, winner of the group, and they up, finding of the root, that is all that so this number, the root, and not less the order, that, therefore,
Full stop, huh? Full stop. The remaining you cut, not required. Mm. Since we have held that the extension of the suspension period by an order dated 3/6/2025 has been passed after a lapse of 90 days. The said contention of the appellants in our considered view would be of to no avail, since the period of suspension for 90 days had already lapsed on the date of issuance of the extension of the suspension. While saying so, we also notice that the appellant has also filed instant appeal not as per the format prescribed in this regard by the High Court rules. So, in fact, the memo of appeal should contain the facts of the case, comma, contention of the petitioner before the learned single judge, comma, contention of the respondent before the single judge, comma, points which arose for decision before the single judge, comma, conclusions and decisions of the single judge, comma, grounds on which conclusion and decision of the single judge are challenged, and lastly, the relief sought for in the appeal. In terms of form number 3, capital A, which corresponds to Rule 2(3) of Chapter Roman 5-capital A of the High Court rules. Nevertheless, we have not rejected the instant appeal on the ground of the appeal not being in the proper format, but we would like to make it clear that any writ appeal filed which is not found in terms of the format as stated here and above should not be entertained by the registry henceforth. Next para. Thus, upon due consideration of the case in its entirety, we do not find any reason to interfere with the impugned judgment and order of the learned single judge, and accordingly, the writ appeal stands dismissed.
Right, my lord. The records, deeply obliged. My lord, the records may be written.
You can take it back. We have seen it.
Deeply odd.
So we'll have to a bit refine the thing. This is the broad outlay. We'll fine tune it. Right.
Item number 14 and 15, it's an admission matter.
These two matters have come up for my disposal, and I'm challenging the judgment and order dated 4/3/2025. In both the cases, my lord, those separate judgment, but the judgments are identical, issues are same.
This is a writ appeal.
Writ appeal, my lord.
This file did not come to us actually.
Matter in fact was posted for today, but it was not listed in the main list. Then it came by way of a supplementary list, my lord.
That's what. The file did not come to us.
Lordship.
We just got to know it in the morning only.
Lordship.
Why is it listed today for admission?
Well, it's for disposal by the last order, my lord. Observation was made, my lord, for admission and disposal. My lord, 22/10/2025.
What is the subject matter?
The facts in nutshell, my lord, is that my lord, the BRO, my lord, respondents, they have, my lord, awarded the contract in question to the respondent number 6. And my lord, respondent number 6 has applied for subcontract for me, my lord. And accordingly, BRO has approved me as a subcontractor. There is no agreement, my lord, reason, my lord, admitted a fact. There is no agreement of subcontract between me and the respondent number 6. There is also no agreement between the BRO and the, my lord, present appellant. My lord. And therefore, my lord, while approving the, my lord, this appointment of subcontractor, my lord, it has specifically, my lord, observed, Lordship may kindly have a look to the, my lord, page 88 and 90, that, my lord, all the responsibility, everything will be, my lord, my lord, fastened with the, my lord, respondent number 6. page 89. The proposal has been examined in the light of provisions of under clause number 4.2 of EPC agreement under CA number so and so. The proposal submitted by firm to allow the petro dump and the present appellant to execute the subject work as subcontractor, as in principle agreed for the subject work to the condition that subcontractor shall not be allowed to execute the work more than 49% value of the project. However, the EPC contractor, Messrs. Velacha Engineering Limited, shall at all times be responsible and liable for all its obligation under the contract agreement. Now, my lord, while continuing with the work, my lord, the respondent number 6 has defaulted, my lord, making the payment to the subcontractor. We have applied, my lord, for invoking, my lord, clause 4.2, where the BRO, my lord, retains the, my lord, power to direct the Velacha for making the payment. Accordingly, direction were also issued, but no payment was, my lord, made. Ultimately, as per their agreement, the milestones, the contract was delayed. And ultimately, an intention of termination was issued, and thereafter the contract was terminated.
Okay, by the way, is there any interim order in this?
No, my lord, there is no interim order on that.
Interim.
Now, two questions arose before the Honorable Single Judge, my lord. Whether, my lord, the appellant, my lord, fulfills the ingredients of section 70. And secondly, my lord, whether the terms and conditions, whatever laid down in the contract agreement with the respondent number 6 or the principal contractor, can be, my lord, imposed on the present, my lord, appellant, as there is no, my lord, subcontract agreement, and there is no, my lord, direct agreement with the BRO. Now, the Honorable Single Judge do not decided the first question as to whether, my lord, all the ingredients fulfills or not, but a direction has been issued that the all pending bills to be released in favor of the petitioner. The directions your lordship will find, my lord. Page 530. And 11 portion. 539, paragraph 14 onwards.
Mr. Saikia, writ petition was filed by the appellant.
By the appellant.
Correct. And what was your case before the writ court? Is that
my case is that I have to execute 49% of the total melody work method.
only 49%?
Only to the extent of 49%.
Why is that? You are a subcontractor.
As a subcontractor.
As a subcontractor.
As a subcontractor, the approval letter I have just shown at page 88. So I have to complete the 49% of the work. Now I have completed more than 49% of the available scope, and the remaining 50%, 51% was to be executed by that principal contractor. He did not do anything, my lord. Even in the termination order also it reflects, my lord, he did not did anything with regard to the contract. Now for the default of the contractor, now, my lord, contract has been terminated. I have nothing to say, my lord. But so far as the work I have executed, I am a local contractor. And this, my lord, clause 4.2 has been, my lord, inserted in this particular agreement of all nature, my lord, by the Ministry of Roads and Transport, my lord.
Just a minute. What you said, your work is to be limited to how many? 49%.
49% of the total work, my lord.
49% of
Lordship,
total work.
Total value of the work was, my lord, 67.
No, that's okay.
Lordship, my lord.
49%, and this is as per some agreement reached by you.
No, my lord. It is only, my lord, as per the approval that has been given
By whom?
by the BRO, Respondent Authority, employer,
BRO has made an approval, gave an approval
Lordship, my
for
lord,
subcontract.
for subcontract to me, my lord. 49%.
Who is the contractor otherwise?
My lord, the Velacha,
Respondent number?
respondent number 6. But as my lord, subsequently, my lord, it has been, my lord, the name has been deleted because he neither contested the writ petition nor, my lord, has appeared here. So he was not a necessary party as such, my lord.
Contract work was awarded to respondent number 6.
6, my lord.
But you are subcontractor.
Lordship, my lord.
And how did you get the subcontract? You don't have any agreement between the respondent number 6 and you?
No, my lord, I don't have.
How is that?
Had that been, my lord, had there been an agreement, subcontract, my lord, this, my lord, section 70 of the contract would not have come into play, my lord, because we will be governed by that subcontract contract agreement. Now, it is only based on the, my lord, that approval that, and therefore, your lordship has seen, my lord, the condition is that, notwithstanding I work, my lord, all the responsibility, etc., is, my lord, levied on the, my lord, respondent number 6. But you may come to once again, my lord, page 89.
No, what is your grievance otherwise?
Now, my lord, grievance is that for the fault of the, my lord, contractor, the contract has been terminated. Now, while calculating the payment for on termination, they have imposed liquidated damage, etc. And thereby my bill has been, my lord, deducted, my lord, from the work for which I have already worked. For no fault of mine, my lord. It is the fault of the contractor. 51% is to be done by him and 49% I am to work. I have said that I have done more than 49% of the work. So I am at least entitled to the amount for which I have worked. If you have anything regarding imposition of damage, my lord, or other things, that you impose on the private respondent number 6. But they have not done a single, my lord, they have taken no action against him. He has been caught free, my lord. And this, my lord, local, my lord, the contractor who has executed with all, my lord, hardships, my lord, and now his entire amount has been, my lord, withheld in the name of, my lord, deducting damages, etc. That is my grievance.
So what was your claim in the writ petition?
My claim was that I should be paid the amount for which I have worked.
To what extent? To what extent?
To the extent, my lord, I said, my lord, I have submitted various bills, my lord, which would go to show that more than 49% of the work has been done, my lord. Now, here during the course of the, my lord, proceeding before the, my lord, single judge, this court has directed that you have a joint valuation of the unpaid work. That was done. Then I had submitted the bills. They did not process. Now again, the matter was, my lord, brought to the notice of the court, my lord, and the court has said, asked the, my lord, why they have not paid. Then the, my lord, respondent BRO took, my lord, 2 weeks time to, they said that bills are in process, we'll be doing the needful. And thereafter they did not do it. And what they did, my lord, unilaterally, they have made some calculation of their own and presented before the court, saying that this is the amount I am to achieve. Whereas it is not as per the joint valuation, etc., my lord, what that has been accepted by both the parties. Now, in the amount which they are trying to show in the, my lord, unilateral calculation, they said that 11 crores and odd I am to receive, and out of that, my lord, something about, my lord, 9 crores and odd to be deducted in the name of liquidated damage, etc. So I am entitled only for, my lord, 3 crores, my lord. So that is the case. But my question is that since there is only document, what is our relationship, what is there is governed by the approval letter, which clearly speaks any fault committed by me or etc., the responsibility rests on the contractor, the respondent number 6.
What was the decision of the learned single judge?
Lordship, my lord.
How was it decided?
Lordship, my lord. Lordship may come to page 539. The judgment starts from 530. page 539, paragraph 14 onwards, my lord.
No, it was partly allowed.
Partly allowed.
Whatever you have to go,
Yes, yes,
you have to go to the civil court.
yes, my lord. Now the ultimate, my lord, page 544, paragraph 24 is the direction. Ultimate directions are page 544, but lots of may come from paragraph 14 onwards, the finding of the court also, madam. Now, this deduction of liquidated damage, etc., does not arise, my lord, on the face of the approval letter, but the Honorable Single Judge has taken recourse to the principal, my lord, agreement, where I am not a party to that, nor there is any reference to that agreement, that those conditions will also be implied on me. Therefore, this deduction itself, my lord, without authority of law, my lord.
We'll do one thing.
Judgment
Mr.
ought to
Saikia,
have,
Mr.
judgment ought
Saikia,
to, Lordship, my lord.
We'll post it some other day.
Lordship,
Today it's difficult.
Lordship.
We have our own respective.
Lordship, that's
taken
true,
up.
that's true, that's true.
So time constraint is there, and moreover, this file came to us just
Lordship, my lord. Yes, yes, that is
advance thing was not there. So yeah. On which date should we have it? As agreed to by the party.
If it can be continued tomorrow, I'll have no problem. Or otherwise, if it can be continued tomorrow, my lord, or otherwise,
Tomorrow not possible.
not possible.
Brother is here only for tomorrow, isn't it?
In that case, I'll be praying, my lord, in January only, my lord.
January.
January, because after a few days there'll be a vacation and all. So
January, third week,
Lordship,
fourth week.
on 19th, my lord, on 19th,
19th.
if not inconvenient to the court, my lord.
Mr. Kato?
My lord.
19th.
Yes, sir.
Okay, list the matter on 19th of January 2025, 26. That's paid for by the parties for final consideration. For consideration, not final, for consideration.
It will be listed in the admission column, my lord.
You write for consideration instead of like that for admission hearing.
Alright.
No problem.
Develop.
Matter number 6.
15 also same. Item 15.
Lordship, it's a connected matter.
They're together.
Together, my lord.
Let me see. Yes. This is item 6.
Yes. And I'm appearing on behalf of Standing Council Tabatagum Education Department, Your Honor. I'm appearing on behalf of Tabatagum Standing Council for Education Department. So,
Education.
yes, Your Honor.
Yes, so
Oh, sorry, Your Honor. It's Health Department.
department.
Yes, Your Honor. So, Your Honor, we are yet to receive a perverse reply from the department, Your Honor. So I seek some more time for filing a counter affidavit.
How much time?
3 weeks of time, Your Honor.
The respondents are health department.
Yes, Your Honor.
There are some private respondents also.
Yes, private respondent is also there, Lordship.
Ministry is also there.
Yes.
Yes, respondent number 14.
Yes. How much time? 3 weeks.
3 weeks, Your Honor.
All right, as prayed for by the learned council preparing for the respondents. Further 3 weeks time is granted to obtain instructions and to file counter affidavit. It lists again after the winter vacation.
Diplomat.
Yes. please.
Item number 7.
IE 2227 of 2024 is a continuation petition, delay of 68 days, my lord, in preferring the writ appeal against the impugned judgment and order dated 14/8/24, my lord.
Where's the objection?
You know, I'm not going to file any objection. I may be condoned. He has no objection. No objection. Delay may be condoned, my lord.
Heard, Mr.
BK Singh, my lord.
BK Singh, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 68 days in preferring the connected appeal against the judgment and order dated 14/8/2024, passed by the learned single judge in WPC number 56 of 2022. Where's the explanation?
My lord, it starts from paragraph 2 onwards, my lord. Paragraph 2, 3, 4, 5, 6, and 7. The counsel of the applicant acquainted the fact of the passing of the judgment to the applicant corporation by the email dated 15/8/2024, stating the honorable court was pleased to partly allow the writ petition by interfering with the NIT dated 25/1/2022, which was floated by the FCI at the risk and cost of the terminated contract.
Learned counsel for the applicants, is it?
Yes, ma'am.
Yes.
Applicants.
Yes, applicants submits that delay has occasioned due to facts and circumstances beyond the control of the applicants, and that there is no latches on the part of the applicants in approaching this court. To substantiate his submission, the learned counsel relies upon the statements made in paragraph number 2 to 7 of the application. He thus submits that the delay in filing the connected appeal may be condoned. Next para, Mr.
Bam, Your Lordship.
Bam.
Yes, ma'am.
Learned counsel for the respondent submits that he has no objection if the delay is condoned and that the appeal may be taken up on merit. Next para, upon hearing the learned counsels for the parties and upon perusal of the materials available on record, we are of the view that the applicants have made out a case for condoning the delay. Stop accordingly the delay of 68 days.
68 days.
68 days. Stands condoned. IS stands disposed of.
My lord, the main appeal may come up after 2 weeks. Meanwhile, I will serve a copy next week.
In view of the appeal, in view of the order passed today in IAC number 227 of 2024, that the appeal be listed after 2 weeks
my lord.
on a date to be fixed by the registry.
And I will serve a copy, my lord, of the memo of appeal within a week.
Counsel for the appellant shall serve a copy of the memo of appeal to Mr. Ibam, learned counsel for the respondent in the meantime.
Obliged, my lord.
Item number 8.
Lordship, I'm appearing on behalf of the legal aid council.
Hmm.
We have not received the paperwork yet, Lordship.
PCR has received, Lordship. Paperwork may be prepared, Lordship. I don't know. Lordship, here, Lordship,
And then probably.
victim also be implemented, Lordship. Victim need to be implemented, Lordship. This is POXO.
Victim?
Yes, Lordship. This is
POXO
POXO
matter?
matter. Yes, Lordship.
That is there's no appeal memo also. Jail appeal. So, Lord, we have counsel.
You are the legal aid counsel.
No, I'm on behalf of the legal aid council.
Who's the legal aid counsel?
You, Bori.
What is the date of judgment?
19 to 25, Lordship. Date of sentencing order 24 to 25, Lordship.
What is to be done? Should we admit the appeal?
There is also the. Indeed.
Hmm?
That delay can be conducted. There will be delay. Yes. I mean,
See, normally what we do in ICON is that whenever there's a jail appeal, the jail appeals, we just admit the appeal, call for the LCR. LCR comes, then people brings to place and just curious upon.
So, yeah, also do the same.
But then we said delay, no?
Delay, but one sentence is to be able to come down.
Anyway.
It's there with me.
The other day we had directed the legal aid counsel to send an application for cognitive delay.
Yes, but then it let's say the person in some cases, like this, the regular counsel for the life exercise, memo of appeal, and with the correct. One million once and to be able to public content. Can we come to the civil One sentence.
Please write down, pursuant to the order passed by this court on 29/8/2025, the TCR has been received from the trial court. Since the appeal is from jail, we're trying to admit the appeal. So accordingly, the appeal stands admitted for hearing. Of delay, if any, in filing the appeal stands condoned. Registry shall prepare the paper book. What about the appeal memo? Is required?
Appeal memo. Because the victim is not included. Otherwise, we go to
No, the appeal memo. What about the evidence?
So in the appeal memo, they can prepare and then include the victim also. They normally prepare.
Where is this letter dated so and so forwarded by the superintendent jail?
Lordship, step has not been taken yet, Lordship, for respondent. Step has not been taken yet for victim, Lordship.
We'll take care of that. I'm
Yes,
asking you about the letter from the superintendent jail. Who is that? 18/6/25.
It is not here, Lordship, in our petition.
Oh, this is the one, yes.
Okay.
How this appeal has been registered on the basis of this? This is a list of convicts. How appeal has been registered like this?
Well, this is convict visa, and then this is for filing jail appeal. Filing jail appeal. So there is a regular company filing.
Please cancel the order. What happened to Mr. Bori?
He's out of station, Lordship, sir. It is a family emergency.
No, he's out of station. That's okay, but then what steps he has required to be done, to be taken by him? What is the instruction?
The matter may be like fixed for hearing, Lordship.
How?
And in the meantime, the paper book may be prepared.
No, he has to also prepare a memo of appeal.
Yes, Lordship.
Please write, in terms of the order dated 29/8/2025, Mr. U. Bori has been appointed as a legal aid counsel. Stop. Since, stop. But again, he doesn't have the papers. How will he prepare? This is the problem.
He's
Lordship, as per the last order on 29/8, Lordship, registry has been directed to hand over all the records, including the relevant papers, Lordship. It is there, Lordship.
Yes, what papers are there?
That too, Lordship.
We have seen
Yes,
only one letter.
Yes, Lordship.
And you know what letter it is? It is a forwarding of list of convict petitioners. With that, how he'll
Yes,
prepare the
Lordship.
memo of appeal? Only names are there.
So next step, Lordship, then instruction may be called for.
They have forwarded the judgment. I think on the basis of the judgment.
What is that? No, what is done normally in such kind of cases? What do you do? So,
After appointment, you have to put a memo. You have to actually require request copy for the Yes, and I'm seeing this again. Code to the case.
who will give him? Who will give him the memo for the record?
It's there. There is a direction.
No, report is there. TCR is there.
So
he needs a copy of the TCR.
yes. Whenever I'm going, the registry will hand over all the all the records. We'll be given the records on the basis of this record. We'll prepare memo of the case.
What did you write? Now, it is also seen that the TCR has also been received. Top registry shall furnish a complete set of the TCR to the Learned Legal Aid Council within 2 days. And the Learned Legal Aid Council shall prepare a memo of appeal on behalf of the appellant. And file the same before the registry with a copy to the Learned Public Prosecutor. Next para, since the conviction is under section 6 of the POCSO Act, registry to issue notice. No, let a notice be issued to the victim. Stop registry shall furnish the notice in the proper format to the Learned additional PP within 3 days. Whereafter the Learned additional PP shall, you're good.
Ms. L. Hage, yes, Lordship.
Additional PP, Ms. L. Hage. Whereafter the Learned additional PP shall cause notice to be served on the victim through the officer in charge of the police station concerned.
Lordship, through PP office, Lordship. Through PP office, Lordship.
Not
Actu-
for the OC.
No, Lordship, through PP office to the OC in charge, Lordship. To our office, PP office, it should be directed, Lordship, not by my name, Lordship, because Lordship, office we have make the arrangement, Lordship, to the PP office, Lordship.
What did I say? What is wrong in that? We are the
Lordship,
PP.
Lordship, but to the office of PP, it should be more, Lordship. So the PP will,
But you are appearing. That's
for
what
the
I'm
additional
confused.
PP, Lordship, I am additional public prosecutor,
I know.
Lordship. Lordship,
That is why we have to write somebody's name, isn't it? You are appearing.
Lordship.
You'll be conducting the case.
Yes, Lordship.
You're not supposed to personally go and serve. I'm saying that they'll be served to you and you will instruct the officer in charge of the police station concerned to serve it to the thing.
Lordship.
Once the notice is served, the officer in charge, the police station concerned shall report back the same through the office of the learned public prosecutor for information to the court. List again, also accept.
Lordship.
After list again after 3 weeks.
Lordship. Much obliged, Lordship.
Back to mention item number 15, 16, and 17. We're making, in fact, this is joint prayer. There's some urgency in the matter also. We're praying for disposal. Today, I understand maybe it's a bit difficult, the promotion matter. Can it be taken up tomorrow, madam?
But this is some urgency is there because it's question of promotion. For the last from since 2022, there has not been any DPC. So either this way or that way, but it needs to be disposed of. Madam. I am for the petitioners. He's from the respondents. But we are making a joint arch for listing tomorrow.
Okay, let's see. Do we have DB tomorrow?
No, no DB.
So that's why, man, if no DB is there, then maybe.
Let's wait for by the parties. Let's the matter again tomorrow. 15, 16, 17.
Right. Obliged.
Obliged.
Another matter, item number 28 and 29. This matter was in fact listed yesterday, the main writ petition. It was and was listed on 17th of December. Well, another friend, I believe, has filed this IA. Maybe because of this, it has been listed today.
Today. So both the matter will be taken up on
17th of December.
Main case is already listed, fixed on 17, my lord.
Main case is what? 163?
163,
Yes,
WBC.
It was listed yesterday.
In fact, it was ordered.
That's paid for by the parties. List this matter on 17th of December, 2025.
Obliged, ma'am.
Yeah, and I'd like to mention item number 9, Your Honor. Or I'm for the petitioner, Your Honor. I've taken consent from the other parties also, Your Honor. This matter may be adjourned for today. At least up to 3 weeks, Your Honor. After 3 weeks, Your Honor.
May I pray for a date, my lord, if not inconvenient to the court, my lord, on 20th of January, my lord, 20, my lord.
Okay.
For admission and disposal, my lord.
Do you agree?
Yes, Your Honor.
That's a joint prayer?
Lordship.
On the prayer made by the learned counsel for the parties, this is the
No,
matter.
it is not a joint, my lord. He has taken my consent, my lord.
Okay. On the prayer made by the learned counsel for the petitioner and not opposed to by the opposite party, this is the matter on 20th of January 2026.
Interim may be continued, Your Honor.
The order passed today shall continue to the next.
There's no interim order.
No interim.
No interim.
Pardon me.
Okay, no interim.
And, item number 10 and 11 on behalf of A. Sharma, Your Honor.
A. Sharma?
Yes, Your Honor.
When do you want it?
On 19th of January 2026, Your Honor.
19th January.
Since the engaging counsel are from Guwahati, Your Honor, so.
Who is the counsel?
A. Sharma, Your Honor.
On the prayer made on behalf of Mr. A. Sharma, learned counsel for the petitioner. This is the matter on 19th of January 2026.
Yes, Your Honor.
Same order in item 11.
Yes, Your Honor. Deeply obliged.
My Lordship, I beg to mention item number 22, appearing on behalf of T. Dada for the petitioner. Your Lordship, we need to file a rejoinder here. So some more time may be given.
How much time?
4 weeks.
Okay, on the prayer made by the learned counsel for the petitioners, 4 weeks time is granted for filing journey affidavit. Just again after the ensuing interrogation.
Obliged.
May I please, my lord? My lord, I beg to mention item number 32, my lord. I'm for the private respondents 3, 4, and 5. So I've taken consent from the petitioners, my lord. Let the matter be listed after 3 weeks.
What is your good name?
B. Nyarus. It is not reflected in the cost list, my lord, but we have already submitted in the Wakalat Nama. So it's not reflected here, though.
B.
Nyarus.
Spelling?
N-Y-A-R-U-C-E.
N-Y-A.
R-U-C-E. Yes.
On the prayer made by Mr. B. Nyarus, learned counsel for the respondent numbers 3 to 5. And not opposed to by the other side. Matter stands adjourned to be listed again after 3 weeks on a date fixed by the registry.
Much obliged, my lord.
Your Lordship, I beg to mention item number 7, Your Lordship. I'm appearing on behalf of M. Boro, standing counsel for CGST. We have filed our affidavit, Your Lordship.
Standing counsel for?
CGST, Your Lordship.
M.K. Boro?
Yes.
Okay. Yes,
My
what do you
lords,
want?
This can...
I appear on behalf of the petitioners. There are two. One is serial number 7, where the pleadings are complete. There is serial number 8, which is connected with serial number 7, where they have filed their affidavit, and we have received it this morning. We may put in our rejoinder to the affidavit filed by the department, and it may be listed then, my lords.
When do you want it? Matter?
My
3
lords,
weeks?
whatever suits my lords, yes.
Huh?
3 weeks.
3 weeks.
3 weeks.
Yes, my lords. My lords, request both serial number 7 and 8 have interim orders if they may be extended till the next date of the hearing.
Mr. Counsel, we can only hear your voice, but we can't see you. There's no
Lords,
visual.
I'm sorry, my video is on. Can you see me now?
Your video is on, but out here, I think the monitor is off. What happened to the monitor?
It's technical difficulty.
Technical?
Yeah.
Only for video. Audio is okay. Okay, on the request made by the learned counsels for the parties, matter stands adjourned for 3 weeks to be listed again on a date to be fixed by the registry. So in the meantime, the respondents are at liberty to exchange their pleadings. 7 and 8. All right.
My lord, the interim may be extended.
Interim order passed shall continue till the next date of listing.
Grateful.
Yes.
Item number 1.
Yes. Where's the file? Yes.
My lord, this is an application under section 11 of the Arbitration and Conciliation Act for appointment of the arbitrator, my lord, actually.
For
the appointment of an arbitrator.
This
to
is
decide.
the first time.
This first time, my lord, it's first application.
Notice will go.
Yes, my lord.
Hard, Mr.
K. Gangadharan.
K.
Gangadharan.
Gangadhar.
Yes, sir.
Learned counsel for the petitioner who submits that by filing this petition. Under section 11 bracket 6 of the Arbitration and Conciliation Act 1996, the petitioner pays for appointment of an arbitrator. To adjudicate the dispute between the parties in terms of clause 7 of the MOU dated 1/5/2023.
Yes, my lord.
Executed between the parties. Next para, issue notice. Available by 4 weeks. Stop petitioner to take steps for service of notice upon the respondent by registered post with ADD within 3 days, 3 working days. List again after 4 weeks.
Right.
Item number 2.
The short question involved in this writ petition is relating to the deduction of excess draw of payment that was, and the law, my lord, is aware that before 5 years of retirement, if the applicant, if the concerned employee has not made any misrepresentation or the fraud, if that salary is made by the employer, then you cannot deduct, my lord. My lord, the case is, my lord will kindly see, have the annexure 1, page 24. The petitioner was appointed as assistant engineer on 31/1/1991. Page 24. Type copy, yes? Annexure 1.
Annexure 1.
Annexure 1 series, my lord. Page 28. 28, my lord will come to page 28 type copy. It's more legible. 2001. Yes. On the recommendation of the Departmental Promotion Committee, the Governor of Arunachal Pradesh is pleased to appoint the undermentioned assistant engineer on officiating. Sorry, Milord, no. Page 24, Milord. I came to the page 24, Milord. Sorry. I apologize, Milord. No. This is, my name appears at serial number 14, Milord. 23rd January 1991.
Yes.
I was appointed as assistant engineer, Milord. Then, Milord, on 22/6/2001, which my lord will find at page 28, the type copy, Milord. So I was given officiating ad hoc promotion as executive engineer, and my lord, I stands at serial number 5, 0103. 2000.
Yes.
Now, my lord will find at page 31.
Are you retired?
No, I am on the verge of retirement. By February, I am retiring.
Okay. And why this recovery is ordered?
Recovered is ordered because, like, from A to G, from my promotion from assistant engineer to executive engineer, I did not clear the accounts examination. So now it has, down the line, it is more than 21 years now. Now I am on the verge of retirement, and which they have proposed to recover the excess amount drawn by me.
How? Wrong fixation of pay?
Were drawn fixation of pay, which they have fixed some 21 years back.
So, thing is that they say that you have been wrongly promoted.
No, pay fixation was done.
I see.
Because I have not cleared the account examination.
So if you don't
clear the account examination, then there cannot be increment. And increment and there cannot be, I think promotion is not barred.
Where's the impugn order?
Impugn order, my lord, will find at page 35. Annexure 36 है क्या? Oh, sorry. 36, my lord. 16 September, my lord, will have 36. Dated 16 September 25, in pursuance of the Director Audit and Pension, Government of Arunachal Pradesh, Naharlagan, dated so and so, 26/6/2025, the pay of engineer Tabatani, Chief Engineer, Design and Planning is hereby regulated with effect after granting first increment, and recovery is to be made. My lord will see at the left column a period. The period first is 01/01/2002, my lord. And then 1/1/2003, 1/1/2004, 1/1/2005, my lord. So this much amount. And then next is, my lord, on implementation of the 6th pay commission, the initial pay of the incumbent is fixed with effect from 1/1/2006 as this is. And on granting of second financial upgradation, MSCP is scheme-wide so and so, the incumbent pay of incumbent on his option is hereby fixed on 1/3/2010 with DNI 17011 due to non-clearance of departmental account examination and his pay fixation in the initial stage as below. Now these are the things. Therefore, the excess drawn 1/1/2002 to 26/2011 may be recovered and deposited into government account. These orders supersedes all other pay fixation done in the earlier and subject to the post checkup by the Director of Audit and Pension, Government of Arunachal Pradesh. Now I am agree with this because, my lord, I am retiring. If my lord will kindly see, if my lord can flip back to page 35 for a moment, my lord. Intimation. It is hereby informed you that the date of your birthday being 18/02/1966, your date of retirement from service is fallen due on 28/2/2026 ANI. In this connections, you are requested to submit so and so, my lord. So I am retiring on this date. So now the law is well settled, my lord. Unless if there is a misrepresentation of the fraud committed by the employee and the pay is erroneously fixed by the employer, in that event, before 5 years of retirement, my lord, or on the verge of retirement, the authority employer cannot recover the money, the excess salary drawn. And that, my lord, that Whitewasser judgment, my lord, is aware, Mohammed Rafiq judgment. And in the very recent judgment, my lord, Jogesar Sahu versus District Collector, my lord, the law has been settled. Unless if there is no misrepresentation of the fraud on the part of the employee, then employer at the fag end of the service career, my lord, cannot recover the excess draw of the salary, my lord. I have the authority, my lord. And on that basis, my lord, Annexure 5, page 46, my lord. This is post Mohammed Rafiq judgment, my lord.
What is the relevant portion?
Relevant portion is at page 47, my lord, para 4. The Honorable Supreme Court, while observing that it is not possible to postulate all situation of hardship which would govern employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement, has summarized the following situations wherein recoveries by the employees would be impermissible in law. Recovery from employees belonging to Class 3 and Class 4 service for Group C and Group D service. My lord, I'm pausing for a moment in this clause, my lord. This is on this notification was issued on the basis of the Mohammed Rafiq, the Whitewasser ratio, my lord. So in the subsequent judgment, In the Jogeshwar Sahu versus District Collector in 2024, the Group A officer has also been considered that you cannot recover the salary, my lord. B2, my lord. Recovery from retired employee or employee who are due to retire within 1 year, my lord. I am in this category, my lord. I am due to retire within a period of 1 month, one year. As my lord has seen that I am retiring on 28/02/2026, my lord. Yeah. So therefore, this impugned recovery order issued is violation on the teeth of the judgment rendered by the Honorable Apex Court, my lord. So therefore, my lord, I respectfully pray that even 3 also, recovery for employees, my lord, just read together. Recovery from employees when the excess payment has been made for a period in excess of 5 years, my lord. These 2 clauses comes in my favor, my lord. Authorities.
Clause 3.
Clause 3 also, my lord.
And what is the other clause?
2 and 3 is in my favor, my lord. Now, exception 4, clause 4, it will not come to me because there is no misrepresentation or fraud on my part, my lord. नहीं ये वाला को दे दो नहीं जोगी सर Well, I have rendered the Jogesar Sahu judgment, my lord. But the issue in this case, but because the applicant, my lord, was the stenographer grade 1, was working in the district court of Cuttack. So in this case, he was also given promotion, and then salaries were given, monetary benefit were extended to him. But when it was placed before the High Court committee for grant of the fund, then the High Court refused. Then the district judge issued a notice for recovery to the petitioner. Then against that backdrop, the single bench of the Odisha High Court held that no recovery, there should be a recovery. And the division bench also upheld that. In the above backdrop, this SLP was preferred, my lord. So if my lord allow me, we can read paragraph 7, my lord. The issue for considerations. Para 7, my lord.
Yes.
The issue falling for our consideration is not about the legality of the retrospective promotion and financial benefit granted to the appellants on 10/5/2017. The issue for consideration is whether recovery of the amount extended to the appellants while they were in service is justified after their retirement, and that too without affording an opportunity of hearing. Paragraph 8, my lord, all the laws have been reiterated. We need not to read, my lord. Para 9, my lord.
So Tara, at this stage, will issue notice?
My lord, kindly suspend this.
Yes.
You can suspend this impugn notice.
Notice may be issued at this stage.
Right, Mr. P.T. Tara, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the order dated 16/9/2025, by which the respondent authorities concerned have sought to recover the excess pay drawn for the period with effect from 1/1/2002 to 20/6/2011. So he submits that the wrong fixation of pay is not attributed to the petitioner, and therefore the same cannot be sought to be withdrawn, sought to be recovered from him, and that too at the fag end of his service career. So he submits that the case of the petitioner is squarely covered by the office memorandum issued by the Government of India, the Ministry of Personnel, Public Grievances and Pensions, Department of Personnel and Training, dated 2/3/2016. More particularly, by paragraph 4, bracket small Roman 2 and small Roman 3 of the said memorandum. The Learned Council has also relied upon the case of Jogeshwar Sahu and others versus District Judge Katak and others, rendered by the Apex Court by judgment dated 4/4/2025 and reported in 2025 INSC 449. Next, in view of above, issue notice, a motion returnable by 4 weeks. Mr. F. Kapil, Learned Senior Government Advocate, accepts notice on behalf of all the respondents. And therefore, no formal notice is required. Petitioner shall, however, furnish requisite copies of the writ petition to Mr. S. Kapil within 3 working days. Next, para having regard to the projection made, it is provided here in the interim that no recovery shall be made against the from the petitioner in terms of the impugned order dated 16/9/2025 till the next returnable date. Just again after 4 weeks.
Similar order in another 2 matters. Well, the designation is only different. Superintending engineer. Rest of the 2, 3 and 4.
Just give the file.
Yes.
What is the difference here?
Difference, no difference, the same.
Date.
Impugned order, page number is different.
Impugned order date.
Date 2/7/25.
In item 3, what is the page number?
Page number is 37, Milord.
Okay.
Is
Item
Joyan.
number 3, you write similar order, but impugned order dated 2/7/2025.
Yes. Yes.
Bracket annexure 3 series.
Third one.
And what is the period?
Period 28 February is retiring. Period.
Excess double is for which period?
Period is 01/04/2003 to 25/7/2030. Synopsis, Milord, is
No. In the order?
Oh, sorry. No, Joyan. Sorry, Milord, just a small correction, Milord, sorry. 01/04/2002 to 03/07/2006 and 01/07/2006 to 18/12/2016. It is in the impugned order.
Where? Impugned order.
Impugned order is at page 37. Correct, I got it. Fine. Milord will find the details at page 40, Milord. Total recovery.
40?
40, Milord. Second. Therefore, Therefore, the excess pay drawn with effect from so and so to so and so.
Two
so and
periods,
so.
two spells.
Yes.
Okay, right, like this, item number 3, isn't it? The period for things is with effect from 1/4/2002 to 3/7/2006, and with effect from 1/7/2006 to 18/12/2016.
Correct.
Page
And
41.
the third one.
The rest will remain same. And in respect of item number 4,
It's page 35, my lord. Period. Page 36, period, my lord will find.
impugn order is dated 16/9/2025. Annexure 3 series. And the period is with effect from 1/4/2003 to 25/7/2013.
And
I'll
my lord,
repeat
this-
again, 1/4/2003 to 25/7/2013.
Correct.
Page 36.
And my lord, this petitioner is retiring on 30/4/2026.
It's okay.
Yes.
Retirement date I'm not given. I'm saying retiring shortly.
I am grateful.
Item number 5.
Yes.
Lordship, petitioner have been challenging the impugn order passed by the Assistant Commissioner, come Executive Magistrate, Dambuk, Lower Subansiri District, page number 32, Lordship.
32. This is a notice.
Yes, Lordship, notice in eviction, execution petition filed before the. And the brief fact of the case is that, Lordship, the petitioner and the private respondent number 4 is a party to the land dispute, which was adjudicated by the village authority. Lordship, village authority in the inter-village customary court, which was named as Dambuk Bango Kabang. The first Kabang was held on 20/06/2023. The Kaba decision was held in favor of the private respondent number 4. And again, the same Bango again conducted the Kaba on the same matter on 20/06/2023. And by reversing the earlier past Kabang decision, the decision was passed in favor of petitioner. Again, in the third round on 24/02/2024, the same Bango Kaba reverse all early, previous Kaba decision and again pass in favor of respondent number 4, private respondent number 4. And accordingly, this impugn order came, Lordship. The private respondent number 4 has filed an execution petition before the Assistant Commissioner, come Executive Magistrate, Dambuk, Lower Dibang Valley District. The impugn is page number 32, wherein the petitioner have been directed to vacate the land which is in position of the petitioner as per decision of the Bango Kaba decision 24/02/2024. That is third Kabang held. So the petitioner was served with a notice of this notice dated 31/04/2020, impugn notice on 11/11/2024. Lordship, how the petitioner have been aggrieved in this by this notice is that, Lordship, the petitioner was not given an opportunity of being heard. Moreover, no notice was so-called notice was issued to the petitioner, nor the copy of the execution petition was provided. So challenging this, the petitioner have filed a representation dated 11/11/2025 on the same day when the notice was received, impugn notice was received. And again, no action was taken by the executive learned assistant commissioner come executive magistrate. And again on 17th November 2025, another representation was submitted, but no action as till today. Lordship may kindly come to impugn notice dated 31 October 2025, wherein this notice have been issued under section 27 subclause 2B of Arunachal Pradesh Civil Code Amendment Act 2022. As per this section, Lordship, as per amendment section, it says that execution and enforcement of the order or the decree passed by the village authority. If a person against whom a decree or order has been passed by the village authority fails to pay or comply with such order or decree within a period of 30 days, the party in whose favor such decree or order has been passed may apply to the concerned deputy commissioner or assistant commissioner, as the case may be, for the execution of enforcement of decree or order of the village authority. It is true, as this provision, the assistant commissioner has passed the notice, but the subclause B has been not complied by the assistant commissioner, as the case may be. The deputy commissioner or assistant commissioner, as the case may be, on receipt of such application may call for record or order or decree of the village authority or execute or enforce the same by following the principle laid down in Civil Procedure Code 1908 in spirit. It has been reflected. It should be followed by Civil Procedure 1908. And under Civil Procedure Code, Lordship, the execution of order is covered under Order 21. And under order, in Order 21, Rule 22, Sub-Rule 2 says, nothing in the foregoing sub-rule shall be deemed to preclude the court from issuing any process in execution of decree without issuing notice thereby prescribed. If for reason to be recorded, it's considered that issue of such notice would cause unreasonable delay or would defeat the end of the justice. This is my case, Lordship. And no opportunity was given to me, and even after filing of my representation, my representation was not considered, Lordship.
Yes, anyone appearing?
I'm for 1, 2, and 3, Your Lordship.
Four is Lordship private respondent, the decree holder.
Is right. Mr.
B conduct, Lordship.
May I, Your Lordship? Can this court have the jurisdiction when there is alternate remedy available to the petitioner, Your Lordship?
Well, what is that?
He can file appeal before the civil judge, senior division or junior division, Your Lordship, against that if he is really aggrieved by the Kabang decision, Your Lordship.
Lordship, I'm not challenging the Kaba decision here, only to the extent of execution.
Execution.
Yes,
Notice of execution has been served upon him.
yes, Lordship.
So what is irregular about this notice?
Notice, Lordship.
And Your Lordship, in my humble understanding, this is a judicial order passed by the Assistant Commissioner also, under the provision amendment of Act of 2022, Your Lordship.
Civil Courts Act.
Yes, Your
Yes,
Lordship.
Lordship.
What is wrong with this notice?
Lordship, I was not given an opportunity of being heard, and I was not given an opportunity to defend my case
In what? In which case?
in the execution proceeding.
When was the execution filed?
According to notice, impugn notice, execution was filed on 30/09/2025.
And then?
It has been learned from the notice only.
And straight away notice.
Yes, yes, Lordship.
Mr. Young, what do you say?
Your Lordship, if this is the amendment Act, Your Lordship.
So what is the amendment?
In section 27B, Your Lordship.
Yes, what is there?
Yeah, Your Lordship.
You simply passed over like that. You should have told me what is there, read it yourself.
Yes, Your Lordship.
See, thing is that execution has been, notice has been issued on the execution case.
Yes, Your Lordship.
Notice of eviction is this, no SOCOS notice.
Okay,
Lordship.
notice of eviction.
Yes. I have to comply, according to this impugn notice, I have to vacate the land within 30 days.
So one has to give chance to the notice receiver also. Show cause why you should not be evicted within this much time. Somebody files execution and simply says that this is a notice, you vacate. This is a shortcut method. At least you should have given some chance.
In that way, yes, Your Lordship.
That's why. Will issue notice?
Yes,
Simply
Your
state you will play instructions if you want.
Yes.
Hard, Mr.
B Kamdak, Lordship.
B Kamduk.
B Kamdak, sir.
B
Lordship. Kamdak, KMDAK.
Kamdak.
Yes,
B
Lordship.
Kamdak. Learned counsel for the petitioner who submits that the petition is aggrieved with the notice dated 31/10/2025 issued by the executive magistrate Nambuk Lower Dibang Valley District by which he has been asked to vacate the land which he is in occupation. Where is the land?
Land is Poblum. Dambuk, Lordship. At Dambuk.
What is the description? Pating area, is it?
Yes, yes. Patin Pat, Lordship. Apology, Lordship. PATYING, Patin Pat, PATAT.
Where do we get that?
Lordship.
Where is the description? Please write which is located at Paching area in Dambuk.
In page number 21, it can be found.
Now,
also.
the notice has been issued without giving any opportunity. No, the notice for vacation of the land has been issued to the petitioner without giving him any opportunity to show cause or submit a reply to the same. Next para, in view of above, issue notice of motion returnable by weeks. Mr. Y. Ram, Planet State Council accepts notice on behalf of respondent numbers 1, 2, and 3. Petitioner to take steps for service of notice upon respondent number 4 by registered post ADB within 3 working days. Petitioner shall furnish requisite copies of the writ petition to Mr. Y. Ram within 3 working days. Next para, having regard to the projection made by the petitioner. Notice dated 31/10/2025 shall remain state till the next returnable date. List again after 4 weeks.
Obliged, Your Lordship.
Deeply obliged.
Item number 6.
Wait, Madam, this is regarding parity of the pay fixation, Madam.
Readings are complete.
Yes.
Your Honor,
When?
today we have received the additional affidavit filed by the petitioner, Your Honor.
Sorry?
Additional affidavit filed by the petitioner, Your Honor. Today I received. Yes, Your Honor. I'm appearing on behalf of T. Tagum, Standing Council for Health Department, Your Honor.
Have you received additional affidavit?
No, I have received from the petitioner, Your Honor.
They have received the copy.
Or you have filed?
Yes.
Yes, Your Honor.
So, Madam, let the matter be fixed on 10th. Because the respondent councils are not today.
No objection.
Parity of pay.
Yes, ma'am.
Of which post?
Madam, this ophthalmics, Madam. Ophthalmics. Ophthalmic.
Ophthalmics.
Yes.
You are seeking parity with which post?
Presently, they're in the same post, Madam. Ophthalmic assistant.
No, you're saying parity of pay. You're seeking parity of pay.
Yes, ma'am. Madam, as per the central government recommendation for the enhancement of pay, Madam, all this department the department, including the health department, there are Madam, the nurses, then auxiliary nurse, then health assistant, their pay will be already enhanced by the government.
This is the only department where the pay has not been fixed for the ophthalmic assistant, my lord.
Okay, we'll let it come up after winter vacation. Is there any urgency, sir?
My lord, the last 2016, the matter is actually
No.
lingering.
Cases of 2023. Cases of 2023. Mr. T. Som, Learned Counsel for the petitioners, who submits that he has filed an additional affidavit this morning. So, Mr.
H. Tai, on behalf of Titagum.
H. Tai.
Yes, Your Honor.
Learned Counsel appearing on behalf of Mr.
Titagum.
Tagum.
Standing Counsel for Health Department.
Standing Counsel Health Department submits that he has received a copy of the additional affidavit. Anybody else? You are
Respondent number 1, 2, 3, 4, 6, and 7.
Miss
K. Wang.
K. Wang Mo. Yes, for the what is that department?
Finance.
Yes, for respondent numbers
1,
1,
2, 3, 4, 6, and 7.
2, 3, 4, 6, and 7. Have you received a copy of the affidavit?
Today they have filed. I have not received it.
And submits that she has not received a copy of the additional affidavit. In view of above, petitioner to serve the additional affidavit. Requisite copies of the additional affidavit to Ms. Wang Mo within 2 days.
My lord, actually, this is a covered case, my lord.
Maybe, but you should give a copy to.
You already served, my lord. I think in the office it is pending. Office is.
Maybe it's in the office.
No, before that, you should tell me that you have taken an acknowledgement. Taba Tarun. Who's Taba Tarun?
Your Honor.
Standing Counsel.
Okay.
Health.
So only that one copy is given to them. What about the others?
My lord, already served copies.
Hmm?
Already served copies, my lord.
No, you have not taken the acknowledgement.
My lord, actually, I have not personally, my lord, served the copy, but through my clerk.
Maybe. So the clerk also should go with the notice form and take the signature saying that I've served copy. Simply saying I've served will not do. The notice contains only one signature. That is on behalf of Taba Tarun. You serve copy within 3 working days.
Yeah.
List again. When?
But on my lord, 10.
After 2 weeks.
10, my lord.
Not 10. You take it thereafter. (16) Tuesday. List again on 16
Obligement.
December.
Item number 12.
Yes, Your Lordship.
Yes.
Lordship, this is arbitration appeal. My lord, Learned Court below has rejected my application filed under section 34. Basically on the ground that my lord, want of an applications for section 14 of the law of limitation, my lord, 1963, my lord. Lordship will find, my lord, what happened in this case, a contract was awarded to the sole respondent, my lord. And my lord, there was a, my lord, the respondent number, sole respondent has not executed the work as per the target, my lord, the fixed by the, my lord, the department. Well, in the meantime, having no option, my lord, contract agreement was terminated, my lord. After the terminations, matter refer to the arbitration, and in the arbitration proceedings, sole arbitrators they passed an arbitral award against me, and that impugn arbitral award, I prepared appeal, the application before the district judge Bomdila under section 34 of the Arbitration Conciliation Act, and during the pendency of that arbitration, sole respondent filed in one IA saying that my arbitrations filed under section 34 is not maintainable is because there is a bar of the bar by limitation. Admittedly, there was a bar by limitation. As per the section 34 subsection provision, the application has to be filed not outer limit of 120 days altogether. But what happened is instead of directly filings before the London court below, I filed the application under section 34 at Siliguri court, commercial court. The commercial court given me an opportunity to file before the appropriate forum. Accordingly, I filed arbitration applications before the Lanet District Session Judge Bomdila. Thereafter, again, there was some clerical mistake. I had to have withdrawn the applications filed under section 34 again. Thereafter, fresh application was filed, and that was registered as civil appeal. And thereafter, during the pendency of that civil appeal, they filed one IA, raising the issues that it is not maintainable as because there is a delay in filing the applications. Admittedly, there was delay, but delay can be condoned as per the provision as contemplated under section 14 of the law of limitation. Where the proceedings was held at wrong forum, there is a provisions that can be condoned by excluding the time taken in the wrong forum, but that has not been taken into consideration.
You are challenging the order passed in the IA.
Yes, madam.
Where is that page number?
Page number, IA, the copy of the page impugn order, page number 151, It starts from 141. 141, Annexure 6. It is order dated 9/9/2025.
IA is for what?
IA, as I have pointed that IA by IA, they raised the issue that it is not maintainable as because it is barred by law of limitation. It has to be filed, not in IA. Preliminary objection has to be filed. In fact, the IA is not maintainable in such case. Miscase at the most, or the raising preliminary objection. Relevant paragraph is just start away. May I take your lordships to page number 149, Para 18, 149, Para 48, I'm reading from para 17. The judgment referred to the herein above clearly goes to show that order passed by the court lacking jurisdiction is known as and void ab initio. Therefore, the order dated 21/9/2025, whereby the commercial court Siliguri had granted an application under section 34(3) of the Arbitration and Conciliation Act 1996 is found to be known as and void ab initio. Accordingly, argument of MS so-and-so, that same may be treated as extension of time for filing applications afresh in this court is not at all found to be sustainable. para 18, Malan. Therefore, in absence of the applications under Section 14 of Limitation Act, I find no reasons to exclude the time taken in proceedings in the wrong court at Siliguri. Accordingly, the applications filed by the opposite parties under Section 34 and Section 34 Arbitration and Conciliation Act 1996 being barred by each subsection 3 is not found to be maintainable in all aspects. In view of the foregoing discussion, this interlocutory application stands allowed and disposed of. Consequently, the delayed applications filed by the opposite parties under Section 34 Arbitration and Conciliation Act 1996 being registered as civil appeal number so and so is hereby rejected. By this IA, my application has been rejected. So there is a the well settled position of law. It is, of course, admittedly, that specific application under Section 34 is not pleaded. However, it is the provisions where the law wrong court, the proceedings was done in the wrong court, that can be excluded by the honorable court.
Correct, but the court says that you should have filed an application.
True,
You do not file an application.
Admittedly, we have not filed.
So how will the court will consider that without
Yes,
application?
but it is understood, as Lordship, that in the civil court, of course, even abatement is also not made under Section 34, However, the court has the power to exclude the time taken in the wrong forum, So therefore, and in the meantime, when the matter was pending,
The court has the power, subject to the applicant filing an application.
True, that admittedly we have
Suo moto, the court will condone the delay.
that has been, Lordship has seen, that has been raised before the learned court below. That argument was also taken place, submission,
Then you should have sought leave of the court to file an application, that's all.
Instead of giving opportunity, straight away, this has been dismissed.
But did you pray for that opportunity?
Admittedly, no prayer was made.
Then?
However, the reliance was been made on Section 14, Argument was placed, page number 147, Para 15, As regards the arguments advanced by the learned counsel, so and so, for taking the order dated so and so, is order for exclusion of time taken in the wrong forum. I am of the considered view that even if the learned commercial court, Siliguri, granted the applications filed by the opposite party under Section 34(3), Arbitration and Conciliation Act 1996, the same being only for extension of 30 days period for entertaining the application under Section 34, subsection 1, Arbitration and Conciliation Act 1996, cannot be taken as an order passed under Section 14 of Limitation Act 4, exclusion of the time taken in the said court, which was lacking in jurisdictions, in as much as the extension of 30 days time under the provisions of the Section 34(3) Arbitration and Conciliation Act, which appears to have been allowed by the learned commercial court, and the exclusion of time taken in the wrong court under Section 14 of the Limitation Act 1963 is completely a different law. Accordingly, I find no. But an argument was placed. Of course, no application was accompanied.
Will issue notice? And Mr. M. Kato, learned counsel for the appellant, who submits that this appeal is preferred. Under Section 37, bracket 1, bracket small c of the Arbitration and Conciliation Act 1996 for setting aside the impugned order dated 9/9/2025, passed in IA number 7 of 2025 in connection with Civil Appeal number 1 of 2025.
And another, my lord, during the pendency of my applications, my lord, they prepared, my lord, the execution petition before the, my lord, the landed court below, my lord. And that was referred to the, my lord, the Lok Adalat. And Lok Adalat, without giving opportunity, and, my lord, the persons who is not authorized has, my lord, put his, my lord, the signatures on the, my lord, the settlement agreement, my lord. Financial delegation, my lord, as per the central government act, my lord, it is strictly prohibited, the financial delegation power, my lord. Therefore, that settlement is also impugned here in Manam.
Ustav, the learned counsel further submits that the appellant has also challenged the order dated 13/9/2025 of the Lok Adalat Bomdila in execution petition number 1 of 2024. What's the ground for challenging this execution?
My lord, after, my lord, the rejection of my application, they, my lord, refer the matter to the, my lord, to the Lok Adalat for settlement, my lord. In the settlement, my lord, the settlement can be, my lord, exercised by the competent authority, not by the official of the, my lord, the respondent department, my lord. And they, my lord, of course, my lord, that will be very difficult to, my lord, bring on record. However, my lord, the official who was present on that day has been, my lord, forced to put his signature, my lord. And it is offshoot of the, my lord, the dismissal order, my lord. Rejection of my application.
This what has been passed as per the agreement.
My lord.
It's as per the agreement.
Yes, my lord. This is subsequent to the, my lord, my rejection, my lord. Rejection of my application. Consequent upon the rejection, my lord, this has been done.
No, see, the award says the dispute between the parties have been referred for determination to the Lok Adalat, and the parties having settled the matter, the following award is passed in terms of the settlement. So this is an agreed order, it seems.
My lord, yes, my lord. Therefore, my lord, I just, my lord, made my fair submissions that this is done by the, my lord, the Lok Adalat authority, but not settled by the, my lord, the competent to settle the, my lord, this settlement.
No, but how do you challenge this by way of this appeal?
My lord, this is, as I pointed out, my lord, offshoot of the, my lord, my rejection order, my lord.
I don't know. What did I say last line? Next para, issue notice, returnable by 3 weeks. Appellant to take steps for service of notice upon the respondent by registered post with AD within 3 working days.
Interim period, my lord. Interim period. there
What
is no-
interim prayer?
My lord, for at least, my lord, till
What interim? What is the interim prayer? What is there to be granted?
my lord, the interim period is my lord, page 16, my lord. It is prayed that they would be pleased to stay the operation on the impugn, please to impugn rejection order.
No, this is a settlement order.
No,
How
my
do
lord.
we- how
First
do
one is the impugn order, my lord. Subsequent is the, my lord, the settlement order, my lord.
No, we'll issue notice on that also. Also issue notice on the interim prayer. Returnable by 3 weeks.
Well.
Yes.
Item number 13.
My pleasure, Your Worship. Well, this is, we are challenging the suspension order, the authority has not reviewed the suspension order after passing the suspension order dated 28/2024. And as per their reply also, they have in the affidavit, they have also replied that they have not reviewed the suspension order. So in view of, I'll just take to section 10, clause 7 of CCS rule.
Where is the suspension order?
Yes, it's in page
17.
17.
This is order dated 11 August.
Yes, but then if you see the next page, it is 28/2024. 20.
Next page means?
In that impugn order 17. Sorry, last the memo number. If you see the memo number, that is 20 August 2024.
So there are 2 different dates.
The main order that is in the that 20 August. Otherwise, in the top it is 11 August 2024.
Digital signature.
Yes,
That one you refer.
that is on 20 August 2024.
So your case is that it has not been reviewed.
Yes.
You have challenged this order.
Yes, Your Lordship. When it is not reviewed, then suspension order it become invalid. As per even the rules 10 clause 7, it says that it has to be reviewed within 90 days. That is one. And another, Your Lordship has already seen the various judgments, Ajay Kumar, Deepak Mali, and then on coordinate judgment, that is Dipankar. May I place that Dipankar? Also in that order also, the Honorable Court was pleased that if the review is not done within 90 days, then the order become invalid and cannot sustain, Your Lordship. So I'll pray that the matter can be disposed of, my lord. Otherwise,
Standing counsel, due to some urgencies, Your Honor, he left the court premises.
Who was the standing counsel?
Taba Tagum, Your Honor.
Taba Tagum.
Yes, Your Honor. Standing counsel for Education Department, Your Honor.
So what is to be done then?
If Your Honor may allow, maybe adjourn, Your Honor.
In fact, matter was listened on last date also, my lord. It was listened for today for disposal, my lord. Well, I'll just Madam, I think matter law is very clear. Your Lordship has seen the impugn order, and then I'll just take to their own affidavit, Your Lordship. I'll just take to the affidavit file, brother.
We'll not hear the other side then.
I think last time also they appeared, they have engaged only juniors, and they said I'm not allowed to appear the matter. That's how happened last time also.
In that case, short date may be fixed, Your Honor, then.
Last time also they have taken the time, my lord.
Have it next week's.
Okay,
Tuesday.
Yes, make sure that that can be
dispose of, we can fix the date and dispose of, my lord.
Please write, by filing this writ petition, the petitioner has sought for his reinstatement in service. No, you cancel that. Cancel, rewrite again. By filing this writ petition, the petitioner has challenged his prolonged suspension without there being any review. Stop. According to him, he was suspended by order dated 28/2024 with immediate effect. But despite lapse of 90 days, no review has been done. Stop. In view of the settled position in law in this regard, the petitioner, represented by Mr. S. Mao, prays for his reinstatement. Mr. T. Tagum, Learned Standing Counsel, Education Department, is said to have left the court premises on account of some certain urgent grounds. In view of above, let the matter be listed again on Tuesday next.
My lord,
9 December.
Monday, Tuesday.
Huh?
It can be on 18. I will be out of station, my lord.
Okay, on 18th. Oh, December, 18th of December.
Obliged.
Item number 14.
Please, Your Lord. Madam, this matter pertaining to appointment of serving most junior engineer to the post of my lord, assistant engineer, and few of them my lord, have been my lord, allowed to hold even executive engineer, madam. Here's the service rules, my lord. Even if my lord, contingency appointment is to be made, my lord, it is to be made from the serving senior most junior engineer, my lord.
Reading exchanged.
My lord.
Counter affidavit is filed?
Yes, my lord. Everything has been done, my lord. So therefore, my lord, now there is a paucity of time. However, my lord, if lordship, my lord, continue to hear this matter tomorrow or on next week.
We'll fix some other day. We'll not continue hearing.
My lord.
There's no scope of hearing. Continue.
My lord, the issue is very simple, my lord. Despite there is a standing memorandum, my lord, issued by the state government, my lord, where my lord, serving junior engineer in the post of my lord, assistant engineer or higher than that post has to be reverted back to their original post, my lord. But that is not complied with, my lord. There is a one standing order, my lord. By this order, my lord, standing order, my lord, those who are presently serving in the post of my lord, assistant engineer or hire the assistant post of assistant engineer, but substantive their post is junior engineer, even junior to me also, my lord, are holding the post of assistant engineer as well as my lord, higher than the assistant engineer. My lord. By this memorandum, at least, my lord, according to the office memorandum, they have to go back to their original post and original substantive post, my lord. But still, my lord, practicing is going on.
Kato, what is your grievance?
My grievance is, my lord.
Yes.
I am entitled for the post of my lord, even if it is appointed on ad hoc basis.
Entitled to what post?
For the post of assistant engineer, as well as above the assistant engineer, my lord.
What are you, otherwise?
My lord, I am serving senior most junior engineer, or some of the, my lord, the junior engineer who is just junior to me in the post of junior engineer. Kedar is malad the malad our Kedar is junior engineer malad. We are in the same putting malad junior engineer, but they are malad holding the post of assistant engineer, as well as malad some of them are holding the post of even executive engineer malad by superseding the seniority list malad.
Who is holding those posts?
Malad, some of them have been named.
You are, first of all, who is the petitioner? You are a junior engineer.
I am junior engineer.
What is your aspiration and what is your prayer?
My prayer is, my lord, even if
You want to hold the post of
assistant engineer, I may be promoted to the post of assistant engineer,
on
even
what basis?
on seniority basis, my lord.
As per what rules?
My lord, as per their seniority list fixed by them, my lord, respondent department.
That is everyone's aspiration.
My lord.
If you are junior engineer, you are aspired to be promoted to assistant engineer,
My lord, irony
and
is,
from the assistant engineer to executive engineer, like that.
my lord, irony is, since we are in the same seniority list, and the persons
We means who?
much below, my lord, some of the junior engineer, my lord, who are in the much below to the junior engineer in the list, seniority position, my lord.
Those who are junior to you are holding the post of
Correct, my lord. Executive assistant engineer as well as the executive engineer, my lord. On temporary basis, on my lord, the ad hoc basis, on my lord, the other terms, whatever they are.
temporary basis,
Temporary basis, my lord.
not on substantive basis.
Yes, my lord.
Then
How long, my lord, substantive, my lord, even it is there, my lord, they are holding the post for that, my lord, in the substantive, my lord, the ad hoc arrangement for last 10 years, some of them are holding, my lord.
so you also want to hold the post in on temporary basis.
My lord, as per the my lord settled position, my lord, since my only avenue is to promote to the next higher post, even if he can choose, my lord, even if ad hoc has to be even from the seniority list, not from the my lord, he can choose by who are much junior to me, my lord.
No, your prayer should be that the post of assistant engineer should be filled up in accordance with the recruitment rules.
Correct, man. That prayer is.
And if that is so, I am the senior most, I have better chance.
Yes, man. Yes, man.
Or are you saying that I also should be given in charge executive engineer or in charge assistant engineer?
Another limb of submission is, my lord, even if it has to be done in that, my lord, the irregular manner, irregular way, my lord, at least seniority has to be taken into consideration, and he has been posted to the at least to that post, my lord. Even we can choose even other method of my lord, appointment, at least that has to be done from the seniority list, my lord. Therefore, the department has, my lord, cautiously prepared seniority list, my lord. So, my lord, on
Will yes matter and some other day?
on 10, my lord, subject to convenience of your lordship. The other party has agreed, my lord, on 10th, my lord.
No, no.
What about the private respondent?
Monday, let's say there's no private respondent here.
If there's no private respondent, how without there being private respondent, how are you saying that they should be brought back?
From the, my lord, the documents annexed by the department.
No. That chance will have to be given to them for hearing. You want to bring somebody back to his own post.
The department is, if my lord, if lordship peruse the affidavit filed by the department, they are, my lord, only
Rightly or wrongly, they are given in charge of some post.
Correct, my lord.
You want them to come back.
Correct, my lord.
Without hearing them, without making them a party, can you bring them back like that?
My lord, as per the standing order, my lord.
As per what standing order?
Standing order, my lord, the standing notification memorandum issued by the respondent department.
Audio ultim partum.
My lord, and
You have to follow the principles of natural justice. Make them a party, give them a chance of hearing.
My lord, department is also saying that we are under process for the, my lord, reverting back to their substantive post, my lord.
Maybe, but
they are not initiating, only saying the in the
department is not the officer. The officer concerned has to be made a party.
Yes, my lord.
Who will suffer ultimately? That person
ultimately, my lord,
he'll be dragged back to his own original post. But tomorrow he'll come and say that I have not been hurt. Why you have dragged me back? Then
my lord, we are not particularly against the, my lord, the one officers and the other officers. My lord, department is not exercising the, my lord, the notification issued by them, my lord. On 10th, my lord, if subject to, my lord, my lord, it's required detailed determination, my lord. Or any other date, my lord, subject to convenience.
Monday it can be taken out.
Monday, I don't know.
Monday I'll be out of station.
Tuesday, lordship.
Monday.
On 16 or 17.
Tuesday is a 9, lordship. And 10, I have a personal debate. Otherwise, on 11, it can be done.
16, you are there?
16, I am not there. Lordship.
17.
Oh, that week, Lordship, I may not be available. 11, 12, it can be done. Lordship.
11, 12, it's the last day for this court. No?
11 or 9, Lordship, Tuesday.
Tuesday, I'll be having the personal debate.
Then you have it next year then.
After vacation, then?
Tentatively, matter can be fixed on 11, Malan.
No, not on 11. 11, 12, will not fix any matters.
Malan. On 18, Malan.
That week, Lordship.
He's not there in that week.
I'm not there.
15, you have not there.
No, I'm not. 15 is the
15 is voting.
holiday.
16,
Oh, week meaning.
22,
That can
22, Malan.
Parties are represented by the respective councils and they submit that the pleadings are complete and the matter may be listed for admission hearing. As prayed for, let the matter be listed on, we could take it next year, 19th, January 19th.
22, Malan.
22 of the
22 December, Malan.
Huh?
22 December, Malan.
We have agreed. Okay.
Yes.
On 22nd December 2025. Okay.
Reply of
Item number 18.
My lord, this is also regarding the suspension. This is also, I have challenged the order of suspension.
Suspension.
Yes, your
But this matter is listed for orders today. Why?
Lordship,
Some notice is not complete or something?
no,
Why this has come in the
it is
orders column?
completed, your lordship. The state has already filed affidavit and I have also filed their reply.
Hmm. Then we get it listed for admission.
Yes, your lordship, by
When do you want it?
by next week it can be. The issue is, yes,
When?
Next week, your lordship.
let the registry to fix the date or lordship.
This is also prolonged suspension.
Lordship, yes, almost 2 years, lordship.
2 years.
Yes, lordship.
It's not been reviewed.
Lordship, in my case, it has been reviewed,
Then
but the review order passed by the respondent authority is backdated, your lordship, which is at, I have annexed page 18, page 43. This is the review order, your lordship, page 43, annexure 6. And we thereafter we have filed one RTI application. Kindly see, your lordship, on top the date is 18th October 2024. And on bottom the secretary GA signs this on 21 October 2024, your lordship. And then thereafter below is also dated under secretary signs on 18/10/2024. Now thereafter we have filed one RTI. Through that RTI, the file noting which reflected that the order is passed backdated, your lordship. Which
order is passed?
In a backdated.
Backdate means?
18 October 2024, which reflects from the file noting, which I have annexed at page 53.
Backdate means from which date? Extension is from 1910, isn't it?
Yes.
Then order was passed on 1810.
Yes, your lordship.
So it's not a backdate.
Lordship, lordship, I'll take your lordship to page 53 kindly. The note sheet of the
I have it. Which part?
note 191.
Yes,
Review of suspension.
yes.
Shri Subrata Sarkar, PA, attached to the Director Elementary, has been suspended from service with effect from 23/1/2024. And thereafter, as per the next paragraph, as per the rule, suspension of government servants, constitution of review committee under Rule 10 of CCA Rule 1965, an order of suspension made or deemed to have been made under this rule shall be reviewed by the competent authority on recommendation of the review committee constituted for the purpose shall not be valued after 90 days. Further, it is being provided that the extension of suspension shall not be exceeding 180 days at a time. Hence, it may be reviewed or continued with effect from 19/10/2024 to 16/1/2025. Through the SRC constituted as there is no report is received from SIC or Education Department. Accordingly, a draft order review is also enclosed.
Okay, so what is wrong in this?
This was not reviewed, Your Lordship.
Hmm? No, the suspension was supposed to expire. Suspension period is supposed to expire on 18 October
Lordship,
2024.
Lordship.
Correct?
Yes.
And the extension has been passed on 18 October 2024
But
before the
here
expiry.
The
Before the expiry.
the review committee said only on 21/10/24.
From where?
Prior to this, they have already passed order, Lordship.
Where's
There
that?
was no sitting.
Where's the 2110? Show me.
Page 53, which just I was reading, Your Lordship.
No, you were reading, but it doesn't say 21. The review sat on 21.
Yes,
From where are you saying that 21?
a note sheet, Your Lordship.
Which note sheet?
Page number is 53, Your Lordship.
Yes, I'm with page 53.
Note number 191. Below is the date 22/10/2024. Thereafter, Your Lordship, note number
No, notice of 2110, correct? Notice of 2110. But show me where does it say that review sat on 2110?
the last paragraph which shows says that, but it does not say, but there was no review. There was no review on that day prior to 18. My contention is because thereafter at note 192 also, Lordship, kindly see, may obtain the approval was not obtained till then. Till 22/10/2024, no approval was obtained. On the
So
next
this,
page,
so this note 191
yes,
was regarding review of suspension.
yes.
Now, suspension review has to be done by whom?
By constituted by a constituted
Review committee.
member committee.
Review committee. Has it been constituted?
Yes, that was constituted.
Where is that? Note sheet does not indicate anywhere that review committee was constituted and this is the recommendation.
Was constituted. That was
Who's appearing for the department? You are there.
Yes, I'm for GA, Your Lordship.
24.
Here-
You are for GA
Government Department.
and GA will represent whom? You are also GA.
No, I'm for Health Education Department, Your Honor. On behalf
No,
of Titagum.
she will be, she says she am for GA.
General Administration.
General Administration, Your Lordship.
Department of
GAD. GAD.
Yes, Your Lordship.
Our side we call it GAD.
Yes.
If you say
GAD, Your
GA, it
Lordship.
means government advocate.
Here also GA, General Administration Department. This is particular.
I know.
He was saying, Your Lordship.
You should have put D also,
Why
GAD.
GAD?
Then I would have understood. GAD means, okay, General Administration Department.
GAD, Your Lordship.
So who will tell us then whether when the review committee was constituted or not?
I'm looking at it.
Lordship,
Actually, here, Your Lordship, because of the criminal case against the petitioner, Your Lordship was arrested accordingly under Rule 10 CCA rule.
Madam, I'm not asking you about that.
Okay, then.
I'm just saying See, the short question perhaps which is to be considered here is whether suspension period has been reviewed within 90 days.
Yes, Your Lordship.
Counsel for the petitioner says that it has been backdated. Later on they said, but they backdate my review. You have to clarify whether it's set within that 90 days or it's set later on. That much only.
90 days, Your Lordship.
Within 90 days.
Yes, Your Lord.
Then produce the records.
Inquiry of 90 days, Your Lordship.
Produce the records.
Then I have
We'll
to
see.
bring the record, Your Lordship. By the review committee, Your Lordship.
When can you produce?
After 1 week, Your Lordship.
Ms. P. Pangu, learned State Council appearing for the General Administration Department shall produce the relevant records by which review of the suspension of the petitioner has been carried out. List again on so and so. When?
Next, after 1 week, Your Lordship.
1 week.
Yes, Your Lordship.
16.
Okay, Your Lordship.
You produce.
Okay, Your Lordship.
That's it. If review was done within 90 days and if order was passed, well and good.
Okay, Your Lordship.
If no, then law will take its
As per note sheet, it seems that they have approved only on 24/10/24. The notice.
All right.
Yes, Lord, the record will reveal.
Mobilize, Your Lord.
This is item number?
18.
You write list the matter on 16, isn't it? In the admission column.
Item number 19 to 21.
Oh, this is already in the admission, sorry. Already in the admission. List again on 16 only. 19 to 21.
Yeah, may I please, Your Lordship. 19 to 20 to 21 is analogous matter, Your Lordship. 108 is for the benefits under Schedule 2 of LARA Act, and second is 107 is for the solution, and the third item number 21 also same. So I think in this matter, my lord, 2, 3, 5 they have not filed affidavit yet. 4, 2, 3, and 5.
In item number 19, WPC 108/2023.
So who will appear?
I appear, my lord, from 1 to 4. On behalf of 4, we have filed.
Who is 4?
The Deputy Commissioner.
So Deputy Commissioner is the authority?
Yes.
To calculate the solatium and whatever and all that, isn't it?
Yes.
This will cover.
So that will suffice, I think.
Yes.
This has been acquired for which department?
This was acquired for the Greenfield Airport, Holongi.
Holongi.
Yes. So this is for Civil Aviation Department. For Authority of India.
They are a party here?
We have met only the State Department only, my lord.
Who will give the money then?
Money, my lord,
State will not give the money.
State, my lord.
State will give the money. Tell me one thing, for whose benefit was the land acquired?
Land was acquired for the airport airfield, but then the petitioners are the affected landowners.
Airport authority.
No, petitioners, I understand.
Yes.
I'm not asking you that. Petitioners, the landowners, they want money, compensation, that's all. Now, the airport is controlled by whom and for whose benefit?
I think it should be Airport Authority of India.
So they're not a party here. Supposing you succeed in the writ petition, then who will pay the money?
Yes, that is, I think, Airport Authority of India.
Court cannot direct somebody who's not a party here.
Yes, that's true.
They will come and say that we're not a party. Why?
My lord, award was passed long time back in the year 2019.
My lord,
they have come up with this in 2023.
Mr. Ratan, see, it's okay. Delay part will sling the but first of all,
yes, I agree, Major.
The paying authority is not a party here.
My lord, then I will pray that I may be allowed to file.
That should have occurred to you in the first day itself. Why you have
In
not
fact,
made
we,
the party?
we were understanding that the state government should pay the.
State government should pay.
Yeah, that was my understanding. But then the land was acquired for the Airport Authority of India.
Is there any notification here?
Yes, notification here.
Let us see how does it say. For whose purpose it has been acquired.
Let me see page 78.
78.
78, yes.
Airport
78.
Authority of India.
Airport Authority of India and the government of Arunachal Pradesh, do they have any agreement
My lord,
for establishing of the airport?
there should be, my lord. There should be.
Because you see the wording here. Whereas it appears to the governor of Arunachal Pradesh that land is needed for at the locality so and so for construction of green airport at Holongi by Airport Authority for Publics. Who has paid you the compensation?
By Deputy Commissioner Papumpara District.
Who has given the money?
District Collector, Papumpara District.
Oh, district collector does not have that money.
But money has to.
Somebody deposited in his account and he gives out the money to them. He's not the bank. Or he's not the person for whose benefit the land is acquired. He's only the acquiring authority.
Yes,
Statutory authority under the LARA Act to. Anyway, you examine.
Yes.
If you have to implement them, you will have to file an application.
Then, my lord, yes, I may be given some. I will examine and I will file an appropriate application. If the airport authority is has to be made party, then my lord.
I think you should, because ultimately, if you succeed,
yes,
despite all the delay in whatever you succeed, then money is to be given to you. The next question is, who will give the money? State will say that why should we give the money? This is for acquired by so and so for that purpose.
Yes.
Then again, you'll be in a dilemma then.
Agreed.
As prayed for by Mr. S. Mao. List these matters.
After vacation, in the month of January, my lord.
Immediately after the
vacation.
Winter vacation.
Winter vacation. Apply.
Item number 23.
Met, please, your lordship. Met, please, your lordship.
Yes.
Lordship, I have taken steps upon respondent number 9, and respondent number 8 could not be taken steps to Dustimo. The address earlier they were there. They have shifted to other place. So I pray before your lordship that I may be allowed to take fresh steps to register a deposit.
To whom?
Upon a respondent number 8.
8.
8, yes.
What address? You have the address?
Address where earlier it was, but they have shifted from there. So we could not trace it out. But on steps upon respondent number is completed to Dustimo. Earlier hearing that we have prayed to take.
No, if they have shifted to another place, what is the point of taking steps then?
We have got the address. Now the address is at Gujarat, your lordship.
Oh, you've got the address?
Yes, your lordship.
Learned counsel for the petitioner, Mr. A. Bhattacharjee, submits that he has got the address of the respondent number 8 and prays that he may be allowed to take steps by registered post with AD for serving notice to the said respondent. Praise the Lord. Let steps be taken within 3 working days by registered post with AD to serve notice on respondent number 8. List again after 4 weeks.
Okay. Item number 24.
And this matter may be taken up some other day.
This is that matter, my lord. It was listed on second. There was an order that the record should be produced, my lord. I think my learned friend has the records. So 22nd of May is the order, my lord. Actually, my lord, this is arising out of a land acquisition, my lord.
No, we
Now,
are not going to discuss.
I'm just briefing the court on the facts of the case. My lord, the LA appeal has been dismissed. Repeated read petitions filed, read appeal dismissed.
No, my lord.
While the interim order was also passed on 22nd of May, my lord, that interim order subject to the writ appeal which was pending. That writ appeal also got dismissed in November 2024. Now, my lord, only issue was, my lord, that they will produce the records to see that whether advertisement has been issued or not, my lord. So I'm just requesting, my lord, it can be kept tomorrow, my lord. As far as the records are concerned, original records are here, my lord. Roshi may peruse those records and this can be disposed of, my lord.
Can it be on 10th, my lord?
Look, tomorrow I'm requesting my friend only for the purpose of records, my lord. The records can be
Other matters already fixed.
returned back, my lord. The records may be returned back, and after that 10th may be fixed, my lord, as per my learned friends. Because the arguments may be, if it is not able to finish, the court is not able to finish tomorrow, my lord.
Now, what was the issue regarding?
My lord, I'm just shortly, I'll just take 2 minutes, my lord. My lord, a land acquisition award was passed, my lord. These people are never in picture, my lord. It was passed in 2018.
That would be wrong, my lord.
You will correct me.
Because I am the petitioner.
You will correct me, sir. My lord, 18,
You're for the petitioner.
I am for the petitioner.
I have filed an
And you are
I am
private
for the
respondent.
private against interim order is operating against me. I have filed an IA. There are 5 beneficiaries, my lord. 4 of them payment has been released, my lord. They have filed a writ petition. This is the 4th round of writ petition, my lord. There they got an interim order. The interim order says this is subject to the writ appeal which is already pending. The writ appeal was pending between the ITBP, the requisitioning authority, my lord, and the landowners, my lord. That writ appeal also got dismissed in 22nd of November 2024. My lord, kindly have the 22nd of May.
This land acquisition process, my lord, on violation of
What has
section 11.
happened, my lord? This is the fourth round of litigation, my lord.
We'll fix it some other day.
Yes.
All right.
Tomorrow, my lord, can it be? I will stay back, my lord, if it is possible. The records may be seen and discharged, my lord. That is the only. Not today.
We are not disposing of today. Let it be on some other.
The records may be discharged of.
Making unnecessary submissions.
No, I'm only requesting the court. I'm not making a submission to you.
Yes.
I'm making a request to the honorable court. The court will decide it. The court will take a call.
When can we have it?
And then, my lord, can it be on 11th, my lord?
11 will be too late.
There are many facts, my lord. There are many facts in the case.
There's an interim order.
Yes, there's an interim order, my lord. So 11th, my lord, because 10th I have a matter, my lord. That's the.
And you take it to the next week, 17th maybe.
My lord, 17th.
15th is a holiday, I think.
Yes.
So either 16th or 17th.
10th.
Can it be 11th, my lord? 11th or 12th, my lord? Only for the records purpose, my lord.
No.
It's a short matter, my lord.
No,
it's covered.
Records will not do. You see, we'll have to hear the matter.
11th, my lord.
My lord, 18 is okay, my lord.
Okay. List again on 18th. As paid for by the parties. Records be produced on that day.
Interim may be continued.
Till the next day, interim order shall continue.
Item number 25.
Please, your lordship. Your lordship, as per the direction of this honorable court, by the your
I'll give you a date. When do you want it?
your lordship.
We are out of time. See.
Your lordship, I will like to inform the honorable court that I have taken steps to the respondent number 4 to 8 as per the direction of your lordship on dated 19/9/2025 to paper publication in 2 local in 2 consecutive days in a local dailies. So that I have taken steps to paper publication.
Where's your affidavit?
I have already submitted. And matter was fixed on 3rd November, but due to paucity of time, matter could not be taken. And it was listed after 2 weeks.
Mr. A. Bhattacharjee, learned counsel for the petitioner, submits that as permitted by this court, paper publication for service of notice upon respondent numbers 4 to 88 has been done. And the petitioner has filed an affidavit incorporating the newspaper publication.
In local daily paper, Arunachal Pioneer, name of the newspaper.
Stop upon perusal of the affidavit dated 24/10/2025. Notice upon the respondent number 4 to 88 is hereby accepted to be complete. Since no one appears for the said respondents, let the matter be listed when?
After 2 weeks, Your Honor.
After 2 weeks, on a date to be fixed by the registry and in the admission column.
Much of it.
Item number 26, 27.
May I please, Lordship?
Mm.
Lordship, the IA has been filed for modifications to interim order. I notice may be issued. I think my friend will file some objection. And since the selection process, it was initiated in the year 2023, has been stalled till date, Lordship, because of the interim order. So therefore, urgency is there. The matter will be fixed on 22nd. And till then, Lordship, if any objections to be filed by the...
Mr. S. Tapin, learned senior government advocate for the applicants who submits that by filing this application. The applicant seeks modification of the interim order passed by this court on 11/9/2025 in the main writ petition. Issue notice returnable by
My lord, first 2 week of January or second week of January, my lord. Because they have filed IA yesterday and they also filed counter affidavit on 3rd, day before yesterday. So we have to file the reply to this, both of the IA and this one
make
counter
a favor
affidavit.
on 22nd. If so required, you seek further time. As of now, you have enough 2 weeks actually.
But
returnable by 22nd of December. Objections, if any, will be filed by then. Mr. S. Mao, learned counsel, appears for the opposite party of writ petitioners. Petitioners,
my lord.
how many of them?
My lord,
68.
68.
As such, no formal notice is required. The applicant to serve requisite copies to Mr. S. Mao within 2 working days. List accordingly.
Obliged.
Item number 30.
When?
May please, Your Lordship.
This is orders.
Yes, ma'am.
Why it has come for orders?
We have to file affidavit, my lordship. We haven't received a Paravis reply much. We need some more time.
Yes, Lordship. Until then, interim may be granted, Lordship.
Respondent number 5, who is appearing?
Private respondent.
How much time you require?
3 weeks, my lordship.
As paid for by Ms. T. Wang Mo,
K. Wang Mo.
learned government advocate. Further 3 weeks time is granted for filing counter affidavit. It is also seen that as per an office note dated 27/10/2025, a Vakalatnama has been filed on behalf of respondent number 5. But however, no one appears for respondent number 5 today. Be that as it may,
My lord,
let the matter be
My lord,
listed.
I have one submission. Till that entry may be entry may be given because that will be in pictures because this is tender case only.
Be that as it may,
Let
the matter be listed again after 3 weeks. Where's the interim order?
Now I'm praying for the interim order because
How you praying? You're for the petitioner?
yes, I'm a petitioner because this is standard matter because they may complete work anytime.
How can the interim be suddenly come like that?
Now earlier
It was taken up on 14/8/2025.
yes. Earlier we have already
You
prayed.
have not prayed for any interim order?
Yes, we have prayed, but
There's no order as such.
We have prayed, but the honorable
There's
court
no
has
order as
not.
such. So all of the sudden, how do we pass an interim order now?
No, my lord, I have already prayed before earlier, but the honorable court has not given the interim order. But he said that there is some error is there from the as this one tender notice.
You filed an application, separate application.
And one this IA also I have filed.
Where is it?
Today only I have filed.
It's not listed. Today your file is not listed. IA for what?
IA for there is as per direction of this honorable court, there is some the document I have to submit. So as per direction of this honorable court.
It will come up in due course. It is not for an interim order, isn't it?
Yes.
But you are pressing for interim order. I'll ask you to file an application if you say that interim is required. Because on the first day, court did not give you any interim protection.
Yes, that's why.
Now today we cannot again say that.
My lord, because this may take a lot of time, because they are taking a lot of time. This already been 4 or 5 months, I think.
File an application saying that why you want interim order. All those things you explain that in the application. We'll consider.
Yes.
It's coming after 3 weeks. Before that, if you file application, it will come up. It's up to you.
Yes.
Item number 31.
31 is for hearing.
May I pray that this matter will be taken up on Tuesday, madam, coming Tuesday.
What is the urgency?
The urgency, my lord.
Hmm?
They have been deprived of the parity of the pay since 2016, madam. The petitioners are drivers of the police department, madam, seeking pay parity,
Pay
madam.
parity matter. Let it come in the January on reopening.
Madam.
Aspirate for list this matter immediately after the opening of the winter vacation in the hearing column.
All right.